May I please, Your Worship? Lord, I beg to mention for listing of two matters.
Huh?
Listing matter,
What? New matter?
new matter.
When did you file?
One was filed on 24/3.
24/3.
My
How come it hasn't come?
Lord, it has not been listed.
How was it listed earlier?
No, it has not listed. And another was filed on 28/3.
28.
Fine.
Okay. Tomorrow.
May I please? Also, similar prayer here also. Also, I file SRD, my lord.
Tomorrow.
My lord, these matters are relating to compassionate appointment covered by the judgment manual
Tomorrow.
pending.
May it please your lordship, my lord, for motion lordship, new
Huh?
matter. For motion lordship, new matter lordship.
Tomorrow.
Obliged.
Bench 3, bench 4, bench 2 matter.
Best two matter lord.
May I please, Lordship? Lordship, I beg to mention a writ petition on Lordship for listing on Friday. Lordship, the urgency is the petitioner is suspended, Lordship, and 90 days period has been over, Lordship. But the suspension has not been reviewed yet, Lordship. Some urgency is there,
When
Lordship,
was he suspended?
in the month of December, perhaps, Lordship.
No time. On Monday.
On Friday, Lordship.
Friday, okay. Friday, okay.
Obliged, Lordship.
Yeah, please, your Lordship. Lordship, I beg to mention item number 3, Lordship.
3.
Yes, Lordship. Want to withdraw, Lordship.
You have to withdraw.
Yes, Lordship.
Miss
D. Datta on behalf of HL Lordship.
D. Kalita.
Datta, Datta.
D. Kalita.
Datta, D. Datta.
Huh?
Datta, D-U-T-T-A.
K. Datta.
D.
D. Datta. Miss D. Datta appearing on behalf of Mr. H. A. Laskar,
Yes, Lord.
Learned Counsel for the petition, submits that instructions have been received from the petitioner to withdraw the writ petition. Who appears for the other side? Mr. R.P. Bora appears for, P.K. Bora appears for Elementary Education Department. Accordingly, the writ petition is dismissed as withdrawn.
May I please, my lord? My lord, I am praying for adjournment of item number 13, my lord.
13.
13, my lord.
On what ground?
My lord, the conducting counsel, my senior Mr. S.P. Chaudhary, is having sudden medical issue. That's why he cannot come today.
Okay, right. Adjournment prayer has been made on behalf of Mr. S.P. Chaudhary, Learned Counsel for the petition. The matter pertains to the imposition of a major penalty on the petition. List the matter after the vacation.
I am obliged, my lord.
May I please, your Lordship? Your Lordship, praying for listing a pending matter relating compassionate appointment.
New matter,
Your Lordship, pending matter.
pending matter. When? Tomorrow?
It's your Lordship tomorrow.
Oh,
All right.
May I please your lord. It's regarding item number 23, my lord. Additional data.
23, yes.
With the consent of other side, my lord. My lord, I'll pray for adjournment of the matter for 3 weeks, my lord.
Who's
For
I'm
You're
the
the-
petitioner. The nature of the matter is that
I know that harassment. thing.
if a shorter date subject to my senior friends, it's just the
Since
confirmation
Bihu
of what
holidays
we've
are
done.
there.
What do you want to do during the Bihu holidays? You have to file an affidavit or?
My lord,
Huh?
I'll have
Okay.
to file affidavit.
Mr. P.J. Fugan appearing for the respondents number 1 to 3. Submits that he has taken the consent for the other side and prays for adjournment. Mr.
M. Sharma.
M. Sharma appears for the petition. Mr. P.J. Fugan is granted. How much time?
Mention
For
please.
3 weeks time,
3 weeks time
my lord.
to file affidavit on behalf of the respondents number 1 to 1. This is the matter of the 3.
If I may pray for a fixed date subject to
Give May, because today is 9.
10th thing. I'm grateful, Your Lordship.
Most of them.
May I please, your Lordship? This matter relates to the provincialization of the music teacher matter. And this, the music teachers, all these music teachers, Sanskrit and Hindi, all this.
Yes, madam.
The appeal has been disposed of by this honorable court with some consideration before the government. The government is still not taking any action, thereby the sum of the petitioner has filed an case before the Supreme Court. The matter is pending before the Supreme Court.
SLP number, I don't have.
I don't have any SLP number and
So the matter is pending before the Supreme Court. So we adjourn this matter. So we'll issue notice.
issue not be-
No point keeping it in the motion stage.
And Lordship may be direction may be given to file an appeal before the secretary to the, under say rule 14, my lord, that I think may be disposed of by the secretary. Under
SLP is still pending, your lordship.
SLP is pending.
Pending.
So nothing will happen. So anyway, right. Heard Miss
A. Bujar Burwa.
Learned Counsel for the petitioner who submits
PDF এটা দিবা।
that the petitioner is a music teacher who claims provincialization of her service. She submits that similar persons have filed an SLP before the Supreme Court.
Yes.
And accordingly, this matter may be disposed of in terms of the decision to be made by the Supreme Court. But then when will it happen? 10 years also it might not happen. How do we know? So what is to be done?
What is to be done? That is the same thing, my lord.
What have I said? Issue notice returnable in 6 weeks. Ms. P. Das accepts notice on behalf of the Secondary Education Department, while Mr. G. Pegu accepts notice on behalf of
Respondent number 5.
Respondent number 5. The counsels for the parties shall obtain the status report with regard to the SLP filed by the similarly situated persons and also give the SLP number on the next date. That is the matter after 6 weeks.
Deeply obliged.
May I please, your lordship, lordship pursuant to the last order, affidavit in opposition has been filed. I pray before your lordship to grant us some time to file the reply.
Okay, we'll issue notice. No point keeping it here.
Yes, your
We have
lordship.
filed affidavit.
We have already filed our affidavit.
So they want to file reply.
Yes, your lordship.
Okay, right. Heard Miss
M. Borgohain.
M. Borgohain appearing for the petition who submits that she be given how much time?
After giving your lordship,
How much time do you want? 10 years? After Bihu can be 10 years, 20 years also. How many years do you want?
3 weeks.
3 weeks. Who prays for 3 weeks time to file affidavit in reply to the affidavit filed by the Secondary Education Department. Prayers aloud. Issue prayers aloud. Issue notice returnable in 3 weeks. Miss P. Das accepts notice on behalf of respondents number
PDF এটা দিবা।
on behalf of all.
Secondary education.
Is it all the respondents?
No, your lordship. 1, 2, 4.
1, 2, and 4. While Mr. G. Pegu
1,
Yes,
2,
for?
3, and 4.
1, 2, 3, and 4. 1 to 4. While Mr. G. Pegu accepts notice on behalf of respondent number 5.
5, my lord.
What about CMJ University? Petitioner will take steps for service of notice upon the respondent number 6 by registered post with AD within 3 days. This is the matter after 3 weeks. And make it 4 weeks, huh? Give them 4 weeks to file reply also.
Deeply obliged.
May it pleases your lordship, my lord. Mala here, mala notice may go, my lord. Initially interim order was passed, my lord, that was vacated, my lord.
Just a minute. Let us see.
My lord, we have challenged page 30. That
Just a
selection.
minute.
It may peruse the interim, I order passed in the.
Just a minute. Page 30.
My lord,
Page 30, you said.
my lord, page 30, my lord. This is the
130.
30, my lord. This is the list they published 24/8/2020, my lord. And thereafter, my lord, they sought for implementation list, my lord, after elapse of more than, my lord, 1 year. even from the date of dismissal of the initial writ petition, my lord.
No, wait. So you had also filed a writ petition earlier.
Yes. Page,
Huh?
page,
What did you pray out here?
my lord, there, my lord.
No, so you had filed for what? Challenging the appointment.
This is,
You are challenging the appointment of the respondent number 4 and 5 herein.
That was dismissed.
That's not dismissed.
That was
No.
dismissed on merit.
initially I filed, my lord.
How can you, now what are you challenging here in this writ petition?
My lord, initially I filed that as per the guideline, 5 marks was not given to me on that ground, my lord. I should be given that mark. The honorable court said you are not entitled. Now, my lord, we have filed this, that as per the education on a service rule, my lord, that 1 year is the validity of the select list. Even after dismissal of the writ petition, I communicated them, and then after also, my lord, more than 1 year elapsed. So,
You see, Mr. Counsel, right now, have they appointed anybody?
yes, my lord, we are challenging that, my lord.
Ah, they've
Yes.
joined.
Yes.
So when
Initially,
did they join?
After vacating the interim order.
Okay, there was an interim order in
yes,
this case.
yes,
And after that, they joined.
yes.
The order in the IA may be perished. That will clarify everything. There is
IA.
IA.
Where is the
That will clarify everything.
This is the order, my lord. Order dated 19/7/2024.
The IA is filed by you,
Yes.
by you, by forum.
Just may I submit one submission, madam. Kindly, madam, consider the interim order is dated 6/2024, and their appointment is of 14/3/2024. Malot, the learned court, while the vacating the interim order, has come to the conclusion that even prior to the interim order, para 14, Malot, the appointment has been made. This is wrong, Malot, and therefore,
Interim order is 6/3.
6/3, an appointment interim order saying that if not appointed, don't appoint without the leave of the court. and they have appointed on 14/3. Matlab in the IA, page 18 is the appointment letter. Page 18, my lord.
Huh?
Page 18 of the IA. They have annexed the appointment letter.
No, that is anyway. The thing
Yes.
is that now they have been appointed.
My lord, now, my
They have
lord,
been
I-
appointed and they are working.
Yes. Now, my lord, I approach the honorable division bench against this, my lord, order. The honorable division bench has said, my lord, that given the liberty to us, my lord, to raise all the contentions in the writ petition, my lord. This is the order. So may I pray, my lord, whether they can appoint even after lapse of the statutory period.
Where is the statutory period?
Yes. Yes.
Let us see.
Man. 690. My lord, Assam Education Department Selection Rule 1981. In fact, that is my pleading also, my lord. 10(3). 10(3) rule reaches
Which one?
Assam Education Department,
Page?
my lord, 697. Relevant. was.
Yes,
My lord, 10(3), my lord.
10(3). Yes,
The list published under this rule shall be valid for a period of 1 year from the date of its publication, my lord. So, which may further be extended for a period not exceeding 1 year. And whether they have extended by some order. Now, list is of dated 24/8/2020, my lord. On
the
this
list
ground.
published under this rule shall be valid for a period of 1 year.
Yes.
From there, may further be extended for a period or not exceeding 1 year.
So therefore, my lord, let them justify how they can, my lord, implement a, my lord, expiry, my lord, select list, my lord. And that too in violation of the honorable court.
Okay, first of all, the issue was decided on merit in the previous petition.
Okay, so that, because of that,
Yeah, petitioner got only 49 marks. The challenge was that he should have been given 5 marks.
but why didn't you appoint?
Yes, that-
Result was all right.
The reason for delay, I am the chief servant.
Let them file affidavit, my lord, I don't know.
Yes, Lordship, yes. Notice, it required notice. Otherwise, this is the reason for delay. Since the issue has already been decided, now Lordship, on the same.
No, but since he has brought out a new issue, it's a
that
statutory
is the
rule.
reason, that is the
Where?
reason for delay.
When were they selected, these persons?
My lord,
When were you selected?
24/8/2020, my lord.
24/8/20. 24/8/20 selected.
My lord. An appointment made on 14/3/2024. my lord.
14/3/24.
An interim order was of 6/3/2024 in this present writ petition, my lord. And they have violated that, my lord.
No, wait. And the earlier writ petition was filed when?
In 2019, my lord, just 1 second, my lord. Page
It was decided on 13/5.
page 35, my lord.
Just a minute. 9/333 of
Yes.
19.
13/5/2022.
And disposed of on 13/5/22.
Yes, my lord. I have communicated this, my lord, on 26/2022. That order.
Then why didn't you, then you had time between May 22 and March 24, you had time. Why did you
Because
do
of
it?
some Lordship, the roster point.
But
was-
anyway, the 2 years, it comes within the 2 years period.
Lordship, that notice may go, will file, because we have to explain the delay there. Reason for the delay report.
On receipt of the verbal information regarding court case against the two posters. So interim order is earlier. Interim order is earlier.
Earlier, then we had withdrawn also then, point on that subsequent para we have.
Correction of roster point 13. 697. 697. Huh? Page 69, 697.
Yes, 11%.
The list for and when was the list published?
Malot, 24/8/2020, Malot.
But there was a pending case.
Yes, pending
Then-
case, Malot, that was disposed of, and I accordingly informed them on 20.
Which may be further extended for a period, so 2 years. So within 2 years they could do, so it was disposed of on 13/5/22. And
Yes.
within 2 years they have appointed.
Whether they have extended that Malot lease, Malot,
They must have extended.
Malot, let them, Malot, file.
You
affidavit of
just
this. I
bring
don't
out,
know.
you see there's nothing remaining, Mr. You don't have any right to challenge. Yeah, your marks are less.
Already
Because,
decided on
Malot,
merit.
because I am not, Malot, claiming one post, Malot, here. I
Then
will
you-
get a
then
chance.
You go file a PIL.
No, Malay service with right, no. Malot. Only I will get a chance if it is they set aside, I have to see the press in the selection. In fact, that is my representation also. I made a one representation that you cannot act,
Okay, right.
expiry. page
Heard
44.
Mr. B.K. Das, learned counsel for the petitioner, who prays for a direction, who prays for setting aside the select list dated 24/8/2020, by which the respondents number 4 and 5 where is that? Where is the respondents number 4 and 5? Where is the select list page?
30, Malot.
30, by which the respondents number 4 and 5.
May I intervene, Malot? I'm sorry, Malot, if lordship permits me, Malot. If lordship, Malot, if not going to issue notice, Malot, then, Malot, if, in that case, Malot, I may be, given liberty to challenge their appointment, Malot.
Huh?
Malot, in the event, Malot, it will go against me, Malot, then I may be given liberty to challenge their appointment, Malot, if so advised, Malot.
I am not doing anything. I am disposing of the matter.
Malot, let me withdraw then, Malot, with lordship may grant liberty, Malot, to challenge their appointments. Because it will affect him. He is still working on ad hoc basis. He was appointed on 2007, Malot. If some dismissal order is passed, Malot, it will.
I
be
don't know. I'm disposing of our thought.
Malot.
So what to do? He wants to withdraw. Mr. B.K. Das, learned counsel for the petitioner,
My
says
lord.
that he may be allowed to withdraw the writ petition
With liberty, Malot.
with liberty to file a petition. Mr. Tabildar appeals for
Higher education.
Higher Education Department. Mr. N. Upadhyay, learned counsel for the respondents number 4 and 5, submits that the petitioners have already joined their posts and are working in their newly appointed posts with effect from?
Just after passing it over. Actually, I have to take the instruction.
Which order?
Interim vacating order.
Interim order vacated on
6/3, Malot.
with effect from,
No, not
with effect from 19th,
Yes.
19/7,
19/7.
from 19/7/2024. That is the date it was vacated, from that date or from the next date?
3 days there.
3 days back.
The vacating order passed by this honorable court.
Vacating order was on 19/7/2024.
Yes.
Then
That after 3 days.
after 3 days.
Yes.
Okay, that's 3 days after the order dated 19/7/2024, which had vacated the interim order passed on 6/3/2024 in WPC 1309/2020. On the, in view of the prayer of the petitions council is allowed. writ petition is dismissed as withdrawn from a with liberty application.
Now, bless.
Then that's it.
Sorry.
No.
May I please, your lordship? Lordship, I ordered it at 29/5/2024. Honorable Court directed me to file an additional affidavit, lordship, explaining the delay occurred in approaching this honorable court by filing the writ. Accordingly, I have filed the additional affidavit, lordship.
Yes, what to do?
Lordship, in writ petition, Lordship, they have silenced the order dated 30 July 2022, annexure 5, Lordship.
Yes,
Page 19. Lordship, initial joining that 6/12/99, then she was only 17 years, Lordship. That is why order has been passed, Lordship. It is rightly passed. Seventeen years, 11 months, 5 days.
Lordship, before passing this order, lordship, just 16 days ago, they have regularized my service. Moreover, lordship,
no, you see, Mr. Counsel, the issue is whether you agree to the fact that your age, as mentioned in this order, is correct or not.
correct, lordship.
End of the matter.
But lordship, if your lordship kindly goes
Otherwise,
to the order dated
Huh?
page number 19, lordship, in that list, 3 persons were terminated, lordship.
Huh?
Allegation is same, lordship.
Correct?
One of them is Nayan Deka, number 1, lordship.
Huh?
He has approached this honorable court,
Huh?
and the honorable court has issued notice of motion in this case, lordship.
Maybe.
As because there is a
Just because motion has been, notice has been issued, doesn't mean that I have got to follow the leader of the pack. Supposing it takes me to up the wrong garden path, should I follow?
lordship, here is a term boy service, lordship.
Huh?
Boy service.
Voice
otherwise also they were illegals, actually, in
Not illegal,
1999.
You see, Mr. Counsel, the thing is that you were not a major at the time of your,
Initially.
yes.
Lordship, before passing this order, lordship, they
What is your case? Tell me your case. What is your case? You joined the school when? You joined the school as what? As a LPS school teacher.
LP teacher.
LP school teacher.
Stipendary teacher, lordship.
LP school teacher when?
At 13,
4/12/19.
Huh?
31/12,
31/12?
82, lordship.
Huh? 31/12?
My date of birth is 11/82 and I joined on 6/12/99, lordship. 17 year, 11 months, 5 days was my age, lordship. Only 25 days to be measured, lordship. And also before passing
You
this
see,
order,
you were appointed on 4/12/99.
Yes, Lord.
6/12/99, lordship.
No, this is your list of dates.
Page 15.
You write something, you say something else. You'll have chai and you'll say you'll have Coca-Cola. What is that?
As per
Date of joining is 6/12. Date of appointment is 4/12. Page 15. annexure
Date
1.
of appointment is 4/12.
date
Yes,
of
Lord.
joining is 6/12, lordship.
Correct. So date of joining is
All
6/12.
Initially, all appointments made by S.N. Sharma, who deputy
It's
inspector.
6/12. Correct. So when the initial order is wrong, is invalid, then how can you, how the subsequent, all the subsequent actions are
Lordship,
wrong?
already the petitioner has served.
But he has been serving for so many years.
So many years, lordship.
Lordship, they actually initially all are illegal and irregular
No
appointment.
illegal appointment, lordship.
Lordship, kindly let
Okay,
me submit. Thereafter, Lordship, BTC authority has took a policy decision. And on the basis of that policy decision, similarly situated persons regularized.
And his case is here, he otherwise he will be eligible, but his initial appointment is due to policy decision. He is 17 years old. How can he?
Lordship, kindly peruse page number 70, Lordship. They
And Lordship,
earlier also they have
can
terminated
accept-
my job, Lordship, but hereafter we have approached the this honorable court, and as per this honorable court's order, Lordship, we are reinstated, Lordship, at page 17, Lordship.
Okay, anyway, let us issue notice, let us see. And
UB Sharma.
Mr. UB Sharma, learned counsel for the petitioner, who submits that the petitioner's regularization order as LP school teacher has been cancelled, as he had not attained the age of 18 years at the time of his appointment as a LP school teacher. He submits that there is no denial of the fact that the petitioner was not 18 years at the time of his joining. Inasmuch as he was 17 years, 11 months, 5 days on the date of his death. Issue notice returnable in 4 weeks. Ms. R.B. Bora accepts notice on behalf of
2, 3, and 4.
2, 3, and 4. While Ms. S. Chutia accepts notice on behalf of that's point number 1. The respondents may file their counter affidavit and the affidavit in position within 4 weeks. You just file it, then we'll that. Okay.
Yeah, please, Your Lordship. Just item number 4, Your Lordship. My submission is wrong. They have joined on 18 September.
18 September. Okay, right. 18/9.
18/9, 2024.
Item 6. Please, Your Lordship.
Item?
Do a call for from the
Yes, ma'am.
respondents.
Yes.
My lord, here some time is required, my lord. Instruction is not the receive or instruction is awarded from inspector, my lord. So some time is required.
You have been asking for time all along, Mr. Counselor.
My lord, this is the recent letter of from director.
You see, this letter is same as the earlier letter that you have submitted.
Yes, my lord.
24/3/25 is the same, and this letter also is the same. The only thing is that the dates are different. That's all.
My lord, the director has informed the inspector of the school, but it is not received by them.
Not received by them. Why not received by them?
So some time is required, my lord.
We'll ask the inspector to come here then.
One last chance, my lord. Last chance.
You cannot just give a letter by changing the date. That's all. The same thing. What has been given on in March, you have given now in April. Don't try to take the court for a ride. Tell the officers. Right. Mr.
You, Sharma.
U. Sharma, appearing for the Secondary Education Department, has submitted a letter issued by the Director of Secondary Education. Letter dated 1/4/25, issued by the Director of Secondary Education, requesting the Inspector of Schools, NDC Nago, to resubmit the area proposal along with all relevant records. So, sir, it is noticed that a similar letter had been submitted to this court, which was dated 24/3/2025. Submitted to this court earlier, which was dated. It is interesting to note that two letters having different dates have both have the same contents. And first up, it appears that the Inspector of Schools is not submitting a fresh arrear proposal for payment of the arrear salary of the petitioner. On considering the above, this court is of the view that the Inspector of Schools should personally appear with the records and explain why the arrear proposal has not been
And one
made.
last, my
However, on the prayer of Mr. U. Sharma, who prays for one last chance to enable the Inspector of Schools to submit a fresh area proposal, the Inspector of Schools is given one last chance to do the same. List the matter on. Give me. List the matter second May. On which date? The by which it is expected that the Inspector of Schools would have submitted a fresh area proposal to the Director of Secondary Education. Mr. B. Sharma appears for respondent.
Placement.
I like to withdraw this petition. Full liberty to file a fresh.
Why?
For petition number 2, my lordship, kindly come to page 7, my lordship.
Yes,
Paragraph 8, can I read it, my lordship? The petitioner number 2 has approached before this honorable court on writ petition number, whereas the honorable court has disposed of this petition on 27/11/2000, directing the respondent number 2 to consider its representation on 14/5/2024, made by petitioner and dispose of the same by speaking order in accordance with the law after verification necessary. But there was a mistake in the writ petition order dated petition number 2 was shown as a retired headmaster. Maybe we have also done mistake and in the cost.
so you want to correct.
That was I want to correct that is and for
You have got to find out also what has happened.
yes, my lord.
Mr.
TK de, my lord.
Learned Counsel for the petitioners. Pray
My
that he-
lordship, I only want to withdraw for petition number 2, my lordship, not for petition number 1.
You file an application.
Because petition number 1 order, we have yet to come before this court. Petition number 1 has not come yet before this.
You file then you file an application for amendment. For easier is you withdraw and you file a fresh. It becomes
Okay,
easy.
madam.
Otherwise, you have got to file amendment and you see, otherwise it becomes problematic.
Okay,
There are two aspects to this writ petition.
yes.
You'll have to amend a lot of the paragraphs also. Mr. Swenso, Learned Counsel for the petitioner, prays that he may be allowed to withdraw the writ petition with liberty to file afresh. Mr. Nfukan appears for the
All the response.
appears for all the respondents. The prayer the petition's counsel is allowed. The writ petition is dismissed as withdrawn, with liberty as paid for.
Thank you, bless.
Yes. Yes, Mr. Sharma. What is your case?
My lord, P Dash will appear, my lord.
Huh?
In this matter, my lord, P Dash will.
Okay, we'll call her, we're waiting for her.
Yes.
My lord, page 50, by this scheme, my lord, Government of Assam has introduced the scheme, Dr. Banikanto Kakoti scheme, my lord. The petitioner has successfully
You are
cleared.
supposed to get what? Cycle? What?
Yes, my lord, scooty, my lord.
Scooty.
Praying similar relief, my lord. The other petitioner has approached this court.
As
with
per the page 15.
Page 15, my lord,
Yes.
yes. We have cleared our exam, secured the requisite percentage, my lord, but we have been denied, my lord. And page 39, my lord, praying.
Maybe it's out of stock for the time being.
I'm deeply obliged, my lord. Page 13, by this petition, my lord, similar, other petitioners have approached this honorable court, praying similar relief, my lord. So at this stage, notice and similar prayer, my lord.
Notice will go, why are you not giving? You have made a scheme to give scooties, you give the scooties. You just have to verify whether they have got the
Yes,
desired percentage. Then you give the scooties.
that may be
What is required to be done?
verification part.
Huh?
There may be some problem in verification, but we'll do that.
What problem is there in verification?
Adoption instruction notice may go.
We can dispose it off also.
I'm deeply obliged.
With that, you verify. And if they come within that OM,
Yes,
you give them
page 15.
what remains. Otherwise, if you wait for their reply, it will take 1-2 years minimum.
I'm deeply obliged, man.
That's it. I looked in instruction.
What instructions do you want?
Without instruction, but it will be difficult for.
What?
Some instruction.
Huh?
Instruction will be required. Why?
No need. Instead of you taking the instructions from your client, from the office,
Understand.
we'll direct the office to consider the case of the petitioner in terms of the OM. And if they're entitled to the same, give it. If they're not entitled, don't give it. If you can't give it, say that you can't give it. You have to take a decision either way. Waiting for your instruction will never come.
That observation.
Yes. Heard, Mr.
A.S. Tapada.
Yes, Tapata,
Yes.
Learned Counsel for the petitioners, who submits that the petitioners have successfully cleared the Assam Higher Secondary Education Council examination, AHSEC, huh? AHSEC examination, comma. He submits that the petitioners have secured the required percentage in the exams for getting the benefits provided under the Dr. B.K. Kakati Merit Award under the Pragyan Bharati scheme, which has been Pragati scheme under the office member, no, where?
Page 15.
15.
15, man.
Okay, may I interpret one? The dropout students are also not eligible for the scheme. They were.
Huh?
The dropout students, as part of scheme, Lordship, at page 15. It is given the eligibility criteria is there.
Correct. So they will look into it whether they're eligible or not. That's all. If they're eligible, they'll give. If they're not eligible, they won't give.
As per the Lordship, they were drop out. So they will not give. Yes, I understand.
As per the office memorandum ECF number 240742 /2024/160, dated, what is the date? What is this?
6/7/24, madam.
6/7?
Yes.
No, not 6/7.
1607/2424.
16/7/2024. Issued by the Secretary to the Government of Assam, Higher Education Department. The petition, next para, the petitioner's counsel submit that the petitioners having secured the required percentage of marks for girls and boys, comma, the petitioners cannot be denied the benefits of the Pragyan Bharati scheme in terms of the OM dated 16/7/2024. He submits that the present writ petition can be disposed of if a direction is issued to the
Respondent number 2 primarily, my lord.
Huh?
Government commission direct, respondent number 2 and 3, my lord.
will be direction is issued to the respondents number 2 and 3. To take a decision as to whether the petitioners are eligible to be given the benefits under the Dr. B.K. Kakati Merit Award under the Pragyan Bharati scheme, comma, as provided in the OM dated 16/7/2024. Also. Mr. A.R. Tabindar, Learned Counsel for the
Higher education.
Higher Education Department submits what?
That, so let's say they does not they do not fulfill the eligibility criteria.
Where? Why? Which one?
That's it, two, clause E, clause E. Serial
That
number
means
2,
that the petitioners
dropout students.
do not fulfill the eligibility criteria in terms of clause 2 bracket E of the OM dated 16/7/2024 as they are dropout students. You are dropout students?
No, my lord, we are only dropouts.
Huh?
You, my,
That's all. Anything else?
That's it. Regarding the percentage of marks also, that also we need to verify.
Actually,
that has been clarified.
why do you say they are dropout students? How do you say they are dropout students?
They have not joined the other courses, other regular courses.
Where does it say that they have got to join for further courses? Where does it say that?
Regular, they should be regular students.
Where does it say that?
Because that
Where does it say? Please do not just say whatever comes to your mind. Where does it say here?
dropout students are not eligible for.
Correct. But how do you say they are dropout students?
Have petition also lordship, they have.
Paragraph, in our categorical statement, my lord, paragraph 10, my lord, paragraph.
No, I want him. Yes, said that.
So I have to
Then-
verify. I have to verify. them.
Huh?
I have to take.
Mr. Counsel, please do not make statements which are not there.
Lords.
Okay.
I'm sorry, Lords.
You see, this leaves a bad taste in the
Lords,
mouth.
I'm sorry, Lord.
Because the next time you start making submission, then this court also will look at, oh, he is the one who's telling a lie that time. Have to be careful with this lawyer.
Lordship. I'm
Please
sorry.
do not, you see, you all are lawyers, you have got to, you have got to earn the trust of the court. For that, you have got to be fair to the court. You cannot make submissions without any basis. There has to be some basis.
I'm sorry.
First off, however, the council for the higher secondary education department
Higher education.
has,
Higher education. no?
higher education submits that he has made the above submission without any basis. First off, next paragraph. On considering the issue raised in this writ petition, this court is of the view that the issue as to whether the petitioners are entitled to the benefits of Dr. Bani Kanta Kataki Merit Award under the Pragyan Bharati scheme as provided in the office memorandum dated OM dated 16/7/2024 can be decided by the respondents number 2 and 3. Accordingly, accordingly, the petitioners are directed to submit a fresh representation to the respondents number 2 and 3 with regard to their claim for being granted the benefits under the OM dated 16/7/2024, along with all relevant documents. Thereafter, the respondents number 2 and 3 shall take a decision with regard to whether the petitioners are eligible to be granted the benefits under the Dr. Banti Kanta Sensor Scheme, Pragya scheme, in terms of the OM dated 16/7/2024. If the respondents number 2 and 3 are of the view that the petitioners are entitled to be given the benefits under the scheme, the same should be given to the petitioners. So, the entire exercise should be concluded within a period of 3 months from the date of receipt of the petitioner's representations, separate representations, which should be, it's a receipt of in the individual representations, petitioner's individual representation, and which should be accompanied by a copy of this order along with a copy of the writ petition. The writ petition is accordingly disposed.
I'm deeply obliged.
May it please the Lord. The last occasion, Lordships express a tentative opinion that this claim of the petitioners may be stale and barred by lashes. Well, I have gone through it. Lordship will find. This has a very secured history.
Huh?
This case has a secured history. Very many times they had to come before this honorable court, and ultimately by order of this honorable court, they were finally granted in 2021 the provincialization. Initially, they came for that granting of benefit of granting aid scheme. That was what happened.
So have you mentioned that they have been provincialized as tutors?
No, as teachers.
As teachers?
Teachers or tutors.
To provincial as tutors, or where is it? Which page?
At page what you will find at page 105. They have been provincialized.
Where is the names of the petitioner?
Name of the petitioners, Lordship will find 106, page 106. They were left out earlier, though they were the petitioners in earlier cases also. One, two, three, four, five, six, seven, 8. Now 7 is before your Lord. Only 7 petitioners are. So this has
So 7 and 8 are tutors.
Yes, 7 and 8 VGT tutor. Others are teachers. One is not there. This Bhupen Rajbangshi, is it there? Just a minute. Bhupen is there. He is there. Bhupen is there, but this Kiroda Hazurika, maybe that's there. Huh? Full night. Povin is there. Kiroda is there. Ramesh is there. Bobita, Bhupen, Simanta Kumar Deka, Hemalata, Bhupen Rajbangshi. See, Bhupen is subsequently he was made teacher, I suppose. Well, it is written there, not tutor, teacher. So they have been given this benefit now with effect from Lordship will find in the first page, 105. First para, last line. With effect from 1st January 2021. That is and then we submitted the representation that, well, all others similarly situated have been granted from 2001 itself. And it is you who has delayed the whole issue. No. These were pursuant to the orders of this honorable court. This honorable court, well, let me give the facts in a gist. The government initially decided to take up 53 junior colleges for research.
No, you see one thing.
Yes.
You come to para 5 at the bottom.
Yes. This is page 105, Malak?
Yes.
Yes. The teachers, tutors whose services have been provincialized under this act shall get paid, and such emoluments as per norms of the state government as per provisions contained in the act, with effect from the date of provincialization of their services, provided he/she is continuing in the service, and they will be treated as fresh appointees. They cannot claim any benefit whatsoever in respect of past services rendered by them before provincialization, and in respect of pension, they will be governed by the new pension schemes applicable to the state government pieces of the corresponding rank. All the incumbents has to keep the undertaking for acceptance. Yes, my lord, this condition they have put, that they will not be able to claim. But my submission is, since from the very initial stage of coming to this court, this honorable court said that they have also themselves admitted that those were wrongly discriminated.
Sir, this condition binds you.
This condition whether should be made now.
Yeah, then you have to, where is the challenge to this condition?
That's right, of course. So in that case, I may have to amend this petition. This needs to be said, this condition. I'm thankful, my lord, I didn't go through this. This lordship has pointed out. This needs to be challenged. My representation also they have not considered. Even that, lordship will say, I will amend the petition.
So you want, so let your representation be considered.
Lordship.
We can dispose it off by telling the government to consider your representation.
That can also be done, my lord. Let the call be taken. If we fail, then and the lordship will kindly indicate that taking into consideration all the decisions of this court earlier given in their cases.
No, I will not say all that. They know everything is there.
We'll have to place it before them.
You can file a fresh representation.
Yes, lordship will indicate that all relevant documents will be.
Your lordship, the representation that has made as an extra, your lordship, that representation may your lordship.
Okay, which one is it? Page?
Not as fresh,
Page
your lordship.
107, that representation.
Page 107.
Yes. That is the representation in 2023, it was filed.
Okay, right.
And
Heard Mr. K.K. Mahanta, Learned Senior Counsel for the petitioner, assisted by Mr.
S. Gautam.
L. Gautam. Also heard Ms. P. Das, Learned Counsel for the Secondary Education Department.
appearing for respondent 1, 3.
Appearing for
With co-creants.
appearing for respondent number 1 and
1 and 3.
1 and 3. Ms. R.M. Baru appears for respondent number.
Lordship, may I leave another matter?
Okay.
Yeah. Lordship will kindly fix a time frame so that they will touch it. Deeply.
Right.
As per law, your lordship.
No, I'll tell them not as per law, do it illegally.
No, your lord.
Has to be, naturally. How can I tell the government, don't do it lawfully? It's a given thing that it has to be done. the petitioner's counsel, no, what have I said? The petitioner's prayer in the writ petition is to direct the respondents to give the petitioners benefits under the deficient system of grant in aid at par with 277 numbers of second post incumbents. What is the second post incumbent? Yes, it is.
First post in
No, what is the second post incumbents? I don't know. What is the second post incumbent?
which has already been provincialized. Second post, your lordship, second time already 48 junior college has already been provincialized and he was left out.
With the 277 colleges that had been provincialized
Already
earlier.
provincialized.
And then there's another in para 2, there is 19 numbers of incumbents of Deomori Junior College. What do you mean? We had already been allowed the same. Who else drafted this? I don't know what you all want. And then you want allow the petitioners to be provincialized in the same manner as specified under order dated 5th. I don't know what you all want, frankly. Who has drafted this? The prayer portion, I am not understanding it at all. Okay, don't say that, huh? This is the petitioner's case is that they were appointed as postgraduate teachers / lecturers in various subjects in Deomornoi Senior Secondary School located in Darang district. Despite being similarly situated as other junior colleges, who have been brought under the deficit system of grants in aid. The petitioners have been left out from being brought under the deficit system of grants in aid. The petitioners have also prayed that their representation dated 28/9/23 should be considered and decided by the authorities for provincialization of their services with effect from 1/2/2001. As similar persons in Deomornoi Junior College and other 48 junior colleges have also been provincialized. Correct? That's right. Next paragraph. The petitioner's counsel submits that the present writ petition can be disposed of if a direction is issued to the Director, Secondary Education, to take a decision on the petitioner's representation dated 28/9/2023 within a specified time period. Next, Ms. P. Das, Learned Counsel for the Secondary Education Department, submits that he has got no objection to the prayer made by the petitioner's counsel. She, however, submits that the petitioners have been provincialized as teachers and tutors as per order number so and so dated 4/2/2021, page 105. Huh? Issued by the Director of Secondary Education, SR. in view of the consent of the parties, this writ petition is disposed of with a direction to the, to whom? To the,
To
to the director, to the secretary, to the
the
secretary,
commissioner and secretary to the government.
to the
respect
secretary, to
one,
the
then
government of
after it
Assam,
comes to
School
the
Education
director.
Department to take the decision on the petitioner's representation dated 28/9/23 within a period of 3 months, a period of 3 months from the date of receipt of a certified copy of the report. Writ petitions accordingly disposed of.
I'm deeply obliged.
Time being animate.
Yes, madam.
May it be pleases your lordship, here your lordship, I have received instruction. Middle. Middle.
So cause notice dated 23/02/24.
Proposed issue is a 23/2/2024.
Inquiry.
First, your lordship, inquiry report is not found satisfactory. Point number 6. Thereafter, your lordship, again re-enquiry into the departmental proceeding has been proposed by the undersigned. Now the enquiry officer shall re-enquire into the department proceeding drawn upon against the delinquent government servant, that is the petitioner.
But you have not answered the main question, madam. Whether review has been undertaken or not. Huh?
Fixed it to your lordship, I will obtain instruction.
Oh.
Whether review has.
If review not taken, then that has to go. That too.
Deeply obliged.
Lordship, this case is basically for non-inclusion of petitioner's name, Lordship, in the PPO. Lordship.
Where is the PPO?
PPO is Lordship at page Lordship 26. Page 26. 26. Kindly come to the page.
Whose name is here?
Lordship, this PPO is issued to my husband, Lordship. Only
So?
my husband's name is no, Lordship.
PPO cannot be given in two names.
No, Lordship, I'm going to that, Lordship. So
Yeah, you
this
two are
PPO
separated or?
No, this PPO relates to the
Your son.
date of my son, Lordship.
Correct.
And my
Is
claim
that
is,
your son is not your son, is not a husband's son?
there is one specific column, Lordship, in PPO, which is at page 28. Your Lordship, kindly
28.
come to page 28.
Yes.
Whereas clause number 13, details of family number.
Clause number 13, yes.
Lordship, only my husband's name is shown, Lordship.
Oh.
And he is a Lordship paralysis patient. And my husband has already submitted an application which is at page 30.
Page 30.
Page 30. Annex K. My husband's application, Lordship. Application for inclusion of name of so and so mother of so and so, declared dead by the Deputy Commissioner Dimahasa Haplang Assam, I ordered it so and so.
When did you marry your husband?
Lordship,
When did you marry your husband?
Lordship.
Long time back. So the deceased is your son
Lordship,
with this husband.
Lordship. And Lordship, may kindly come to the next of kin
He's
certificate.
paralyzed. So
Not
let
the
it be, let your name be included, but let him receive the pension. What is
No,
wrong?
no, that, I have not that difficulty, Lordship. This is
You
inspector-
want your name to be
difficulty
there.
is that, Lordship, if
She
my
dies,
husband
dies.
dies, then Lordship, problem will be. there.
Correct. Yeah. So yes, find you considering. Have you filed a application to them, representation?
Lordship already pays 30, Lordship, pays 30.
That is the petitioner's husband, na?
Husband, my husband submitted that application.
What about you?
Lordship,
How did he submit? He went walking.
Lordship,
Huh? Paralyzed person. How did he submit it?
Lordship, your Lordship may kindly see,
Or you made it for him?
Lordship, page number 22, Lordship. Page number 22. The highest amount was sanctioned to me. Pension paper submitted both my husband and myself, Lordship.
Page 22.
22, Lordship. Page 22. The amount is payable to his mother and legal here, Srimati Dipti Rani De. And the next of kin is, kin certificate is very specific, Lordship, which is at page 18.
You see, we can dispose of this thing by directing the authorities to look into the letter. But family pension, let it remain with him.
No problem, Lordship.
No problem,
for
no?
inclusion of name
Only your
of
name should
13.
be included. Whether your name can be included, because we do not know.
Only in clause 13, Lordship.
Who is the respondents here? Let them take a decision as to whether there was a mistake in not including her name in the PPO. Because PPO not required, but in the family declaration.
Family declaration.
Because he is apprehensive that if the husband dies, then everything gone.
Lordship.
But if she gets now, since he's paralyzed, might run off with some other person also.
Not too old
Huh?
for that.
That is one danger.
Lordship.
Okay, right. Heard, Mr.
H. Taluda.
H. Talukdar, the learned counsel for the petition, whose grievance. Your time will come, madam. Okay, anyway, since you have already stood up, I'll take your names. Miss H. Talukdar appears for the petitioner. Miss P. Das appears for 1, 2, and 3. Miss J. Gogoi appears for? For number 4. Mr. G. Pegu appears for?
5 and 6.
5 and 6. Mr. M. Barwa for 0.7. Okay, right. The petitioner is aggrieved by the non-inclusion of her name in clause 13 of the PPO number ADP/PPO/GPO/2023/088567, page 29. Huh?
Page 28.
Huh? Page 29. 29. No?
28, Lordship.
20.
28, 28.
28. Okay. But PPO number is correct or not?
ADP PPO public DPO public 2023 088567.
So that's correct. Next paragraph. The petitioner's case is that her son with her husband Salil Kumar De, Salil. That is Sanjay Kumar De, a science graduate teacher of Maibang Higher Secondary School, went missing since 25/8/2010. The petitioner thereafter lodged an FIR before the Maibang police station. Full stop. However, the police failed to trace out her son. And accordingly, the officer in charge of Maibang police station issued a report on 10/4/2011. Where is this report?
Report is at page lordship. Annexure page 15.
Page 15.
Page 14 lordship, type copy. Type copy.
Page 14.
14, 1/4.
Okay. To the effect that the petitioner's son was missing. Next para. The petitioner thereafter preferred an application before the Deputy Commissioner Dima Hassan, Assam, which led to the Deputy Commissioner issuing an order dated 29/2/2020, declaring the petitioner's son Sanjay Kumar De as dead. The Office of the Deputy Commissioner thereafter issued the legal aid certificate. What?
Legal certificate.
Huh?
Page,
No.
page lordship 18. Page 18.
Legal aid certificate on 7/6/2021, wherein it showed no, which is as follows, huh? Page 18, here to here, okay. Next para. A death certificate. Where is the death? Is unreadable. You are giving all
Death
this.
certificate page 17, lordship. Death certificate page 17.
Can't read.
Date of death, lordship 29/2/2000.
Who is this
20.
issuing? Okay, right. The death certificate, a death certificate was also issued on 4/11/2020, showing that the petitioner's son, no, that the son of the petitioner and Salil Kumar De, and that is Sanjay Kumar De. This is not Sanjoy, this is Sanjay. Sanjay Kumar De had expired on 29/2/2020. Next para, next para. The petitioner's counsel submits that the petitioner that the petitioner's name should be included in the family declaration in the details of family members of the deceased, of her deceased son, as the absence of her name could lead to stoppage of family pension when her husband Salil Kumar De expires. The petitioner's counsel further submits that he does not wish to press his prayer for being given family pension in the name of the petitioner, and that the family pension can be continued to be given to her husband, Salil Kumar De. Correct?
That's it.
He also submits that the petitioner had submitted a representation to the Director of Pension, bracket respondent number 6, and the Treasury Officer, Maiba, bracket respondent number 7. Praying for, no, petitioner's husband had submitted, huh? What have I said? That the petitioner's husband had submitted, huh? Praying for inclusion of the name of the petitioner as a family member of the deceased so-and-so, huh? And to allow the petitioner to draw the monthly family pension. The petitioner's counsel submits that the said representation dated nil.
29/7.
Where do you get the date?
Receipt date is 29/7.
29/7/24. Issued by the petitioner's husband. Should be considered. And a decision taken by the respondents number 6 and by the respondent number 6.
6.
By respondent number 6. Will it be 6 or will be a department? It
Director of
cannot be
pension
6.
laws actually.
Huh?
It can be corrected by the director of pension laws.
By the respondent number 6. But in secondary education is also required, I think.
They have no.
By the respondent number 6. Oh, sir. Mr. G. Pegu, learned counsel for the respondent number 4 and 5.
5 and 6.
5 and 6. Here for the director of pension.
My lord.
This is the counsel for the respondents. Submit that they do not have any objection to the prayer made by the petitioner's counsel. Correct? In view of the issue raised by the petitioner hearing being with regard to questions of fact, this court is of the view that the concerned authorities should take a decision as to whether the petitioner is the mother of the deceased Sanjoy Kumar De and the wife of Salil Kumar De. In the event the respondent authorities come to a decision that the petitioner is the mother of the deceased Sanjoy Kumar De and the wife of Salil Kumar De, you cut that wife part. Cut that wife part, huh? Both. Just the mother is enough. Maybe may not be her son, maybe married later on. We don't know. It comes to decision that the petitioner is the son of, is the mother of so. The petitioner's name should be included in the details of family members of the deceased Sanjay Kumar De by the concerned authority. The entire exercise should be undertaken, should be concluded by the respondent number 6 within a period of
1 month.
Enough. Within a period of 1 month from the date of receipt of a certified copy of the file. Writ petition is accordingly disposed of. Okay, item 12, that compassionate appointment, that one.
Yes,
Huh? Mr.
A Das, my lord.
A. Das appears for the
Petitioner, my lord.
petitioner, who appears for the respondent,
But I appear for my
Mr. G. Pegu for
two,
Miss,
three,
both G.
four.
Pegus.
2, 3, 4.
Now, how do we write? This is G. Pegu for and G. Pegu for. What does your G stand for?
Girin
Giri.
and he is Ganesh.
Okay, you're right, huh? Mr. Girish Pegu appears for
2, 3, 4 and 5.
2, 3, 4 and 5. Mr. Ganesh for
1, 6 and 7.
1, 6 and 7. Okay. Disposed of.
Obliged. 29 to 31. Lordship.
Your Lordship had asked us that this new writ that we had filed, which is 8/24 of 2025. To be listed.
Yes.
Yes,
So in this 8/24, when are you filing your affidavit?
Lordship, 2 weeks time, Lordship.
2 weeks. Okay, now, is this correct? This, where is that page? Page 68 in WPC 4087. You don't have it?
No,
What then how do you manage? You are very good at making submissions without any files. Huh? Everything is in your head, everything inside. Photographic memory. Look, he's saying, have you got the second, give them the second copy of this 4087. Next time, please bring your own files, okay? Come to page 69.
yes, Lordship.
The last sentence. 11. So, the thing is that it is final, no doubt. The decision taken by the SLC, no? By the SLC. However, he has made a challenge to the same. So, till a decision is taken by the authorities, let the interim order continue.
So the order passed is based on the CID report, Lordship.
Correct.
And in the CID report, there is a detailed finding, Lordship.
So you
So-
file your affidavit fast. When will you file? Then we'll dispose it of. What I'm planning to do is, since a interim order has already been passed in these two cases, I will transfer that interim order to this 824, and these two cases I will dispose of as infractors. Because otherwise, already interim order passed earlier. That's why.
Let
You
me
file-
stay after 2 weeks, Lordship.
824, you file your affidavit,
Yes, Lord.
and we'll finish it off. But
Okay.
till then, let him be protected. Yeah.
Okay.
Okay, right. Heard Mr. R.B. Fukan, learned counsel for the petitioner in both the cases. That is item number 2930. 2930. Who appears here for? Health Department.
No, Lordship.
Who is for health?
Um,
Call Mr. B. Gogoi. B. Gogoi. And Mr. B. Gogoi for the Health Department. Also heard Mr.
C. Sharma
C. Sharma for
for respond number.
WPT. This one.
Lordship, here,
Who is for WPT?
Lordship, I am for.
Just say for WPT and BC department.
BC is
Mr.
different, Lordship,
Huh?
now. BC is different, Lordship, now. They have been bifurcated, Lordship.
I'm not on that. That's enough. And Mr. G. Pegu, learned counsel for the state respondent. Then,
Social justice also I am appearing.
okay, anyway, right. In view of for WPTC and the BT and PC and which are the department?
Social justice
And social justice
and empowerment.
and empowerment department. Okay. Have you got it? in view of, no, that's right, in WPC 4087/2024 and 4440/2024, the petitioner had put to challenge the cancellation of his caste certificate. First of, however, in view of the decision having been taken by the SLSC
Yes, sir.
on 1/2/2024, recommending cancellation of the petitioner's caste certificate. This court is of the view that the present two writ petitions have become infructuous. Accordingly, the two writ petitions are dismissed as infructuous. Next, in the 824. 824 in item number 31. Same, so I think out here, same, heard Mr. Senator, or other say. Then you write. Then you take this order dated 7/4/2025. Passed in WPC, this, the last order here, 4087. You just take it, here. Para 11. Then next para, next para, para 12. This court, on considering the fact that the SLSC had taken a final decision, with regard to the caste certificate of the petitioner, to the effect that a recommendation for cancellation of the same had been made. This court had closed WPC 4087/2024 and 4440/2020 on the ground that it had become infructuous. Next. The SLSC order dated 1/2/2025, having been put to challenge in the present writ petition, and as the interim orders had been passed in the other two infructuous writ petitions, which resulted in the petitioner being given, and which resulted in the petitioner being given provisional admission to the first year MBBS/BDS course for the session 2024-2025. This court is of the view that the interim order passed in WPC 408, the interim order passed. No, this court of the view that the interim order passed in the earlier writ petition should also continue in the present case. Till the next day. Accordingly, accordingly, the interim order, accordingly, the provisional admission given to the petitioner for the first MBBS course for the session 2024-2025 in Tezpur Medical College shall not be disturbed till the next day. Okay. List the matter on, when do you want? No, list the matter on, when?
After 2 weeks, Lordship.
Give a date.
38.
on that, the Mr.
C. Sharma.
C. Sharma, who is to give the affidavit? All the respondents, the respondents' counsels shall, in the meantime, submit their affidavit. Huh? You inform Mr. Gogoi also. Item 29, there's an IA. IA is disposed of in terms of the order passed in the main case. Huh?
Extremely great.
32.
This is the second occasion Lordship, before Lordship, my lord. Earlier occasion Lordship has passed an order disposing the writ petition to pass an appropriate order regarding my promotion so that I can get from the my lord date of my item number 32. My lord. The order was at annexure 11 at page 59, it is started, and
Item
11
52.
at 61, my lord. And that was my lord finally rejected by annexure 13. So I am before your lordship again.
32. Show me the order, impugn order.
My lord, this is MP order is the last annexure, it is page 63. The tribal grounds has been given to reject the minor my representation. It is not at all acceptable.
Now, what are the, let us see the OM. Page 53.
At page my lord 53.
Yes. Show me where
Well, it
where
is.
promotion will be from the date of
Yes, my
eligibility.
lord. Come down at clause 3, my lord.
Clause 3.
Yes, my lord.
Yes.
Well, it is not, if candidates applies for the promotion on compliance of the minimum eligibility, require period of period and successful in the date of the promotion shall be from the date of the minimum period of eligibility, my lord. It is eligibility in accepted in all the my lord occasion. Now, my lord, whenever I giving the promotion, now they are saying that from the date of notification.
From the date of no, they said has been applied including due to the cabinet decision.
But cabinet decision, there is no such cabinet decision at all. There is not notified even, my lord. And so far in the cabinet decision they relied, that is regarding the my lord 1/4/2024, my lord. That is a
Anyway, we'll issue notice.
yes, my lord, one prayer, my lord, the interim, because my lord, my lord, promotion is otherwise used in 24/23, my lord. One can be a 23, and another two is 24. So I may be allowed to file the application for promotion. That is pending, my lord, but it's not necessary to be considered, but I may be allowed to file, my lord. This is the only payment.
You see one thing, your cabinet decision, the decision by itself, whether it can have any effect, I don't think it can be enforceable unless it has been acted upon by way of notification by the government under 166. So unless there is a government notification, cabinet decision is neither here nor there. It's subject to change, subject to modification, subject to change. And in any event, how can a cabinet decision override the OM unless there is a separate OM? Setting aside the earlier OM. Because all government decisions are presumed to be valid.
My lord, I'll take instruction.
You take instruction?
Yes. And in my promotion order, they have never whispered regarding the any cabinet.
So, no, now this is for CAS grade 2.
It is from my promotion from stage 2 to stage 3.
Stage 2 to
But by
stage
this
3.
time, I will from stage 3 to 13A, my lord.
Stage 3 to
13A.
13A.
It's the associate professor. Already acquired eligibility in 24-23, my lord.
You are eligible when?
I will not be eligible for stage 2 to stage 3 in the year, my lord, 2018, my lord. And my subsequent promotion is to be due on from India 2024. But that was
When?
India 2023, one candidate and one candidate, two candidate 2024. But because of this promotion now, my lord, again, my lord, I will be back to the another for 3 years, but I have
You
to
have got to wait for a few more years.
yes, my lord. Which is applied. By this time, I retired from service, my lord.
How does it matter? You'll get the money if you win.
No, my lord, I am not getting the promotion, not getting the money, my lord.
You want to sit in a bigger chair. Heard Mr. P. Mahanta, learned counsel for the petitioner, who submits that in terms of the office memorandum,
Maybe, my lord, one matter is basic.
who submits that in terms of the office memorandum dated
Eight, 11,
8/11/2023. If a candidate applies for promotion on completion of the minimum eligibility period under the Career Advancement Scheme (CAS) and is successful, the date of promotion shall be from that date of minimum period of eligibility. Next paragraph. The petitioner's counsel submits that the petitioner had earlier filed WPC number 1464/2025 on the ground that the date of eligibility of the petitioners for under the CAS promotion to stage 3 assistant professor selection grade was 25/10/2021, 28/12/2021, and 6/3/2020. Full stop. However, the petitioners had been given their promotions with effect from the date of the notification promoting them to stage 3. That is on 9/12/2024. The petitioners had thus prayed for a direction to be issued to the respondent authorities to promote them from the date of eligibility. Full stop. Next paragraph. This court disposed of WPC 1464 of 2025 by order dated 17/3/2025 with a direction to the Secretary to the Government of Assam, Department of Education (higher), to dispose of the petitioner's representation dated 17/1/2025, which had prayed for granting them, which had prayed for counting the paid for grant of promotion from the date of eligibility and not from the date of notification, not from the date of the promotion notification. From the notification promoting them, Next paragraph. In pursuance to the order dated 17/3/2025, passed in WPC 1464/2025, the Secretary to the Government of Assam, Higher Education Department, issued a letter dated 1/4/2025, rejecting the claim of the petitioners with a slight modification. That is, it decided to give the date of promotion to the petitioners from 1/4/2024 on the basis of a cabinet decision. The first of the letter dated 1/4/2024 5 also stated that the cabinet decision would prevail over the OM dated 8/11/2023. Next paragraph. The contents of the impugned letter dated 1/4/2025 is reproduced here below as follows, page 63. Next, issue notice returnable in 4 weeks. Mr. S. Das accepts notice on behalf of all the respondents. He is granted 4 weeks time to file affidavit in which he shall annex the cabinet decision which has been referred to in the impugned letter dated 1/4/2025. The petitioner the counsel for the for Higher Education Department shall also obtain instructions and clarify as to whether any government notification / order has been issued in pursuance to the cabinet decision made for taking a decision in terms of the letter dated 1/4/2025. This is the matter of the 4 weeks. Acha, one more thing, right? The petitioner's counsel submits that as the petitioner's promotion would have to be considered from the date of eligibility in terms of the CAS, the petitioner may be allowed to submit his application for being promoted to stage 13 in term
Stage 3 to 13A, my lord, associate.
Stage 3 to
13A.
13A.
Associate professor.
Promoted to 13. That's what I said, 13A. Promoted to 13A in terms of the CA. And the pair of the petitioner's counsel is allowed. He may submit his application for promotion to 13A, which however shall be kept in suspense by the respondents till a decision is taken. In this case. Yes. You can take advantage. No one is here. Oh, sorry, they have just arrived.
Lordship, may I make this, Lordship, matter can be passed over for the day?
Oh, you have just answered his prayer.
We have not filed our affidavit here.
That's why I know, that's why. Mr. P.K. Bora, Learned Counsel for the Secondary Education Department. And Ms. R.B. Bora for
I am appearing for 3 and 4.
3 and 4. Are granted 4 weeks time. Senior is not here, so. How much time, madam?
Lordship, I have received some instruction also, 2 weeks. And he needs some more time like.
How much time?
2 weeks will be enough.
Are granted 3 weeks time to file affidavit in a position. File it, please the matter after 3 weeks.
Blessed.
Acha, Miss RB Bora submits that she has received parawise comments. You have to file now. I have recorded that.
May I please, your lordship? It's a pension matter, lordship.
Yes, what is the decision taken?
Yes, madam. Madam, regarding the clarity, yes, ma'am. That one. Regarding the clarity, one committee was constituted to re-examine the matter, and thereafter it was sent, the findings of the committee sent to the government for their necessary instruction.
So you all have not decided till now.
Yes, yes, till that.
Let them decide, madam. It's a huge amount. You see, unless they decide as to whether they are going to recover that excess drawl, it's difficult to take to grant your prayer for the time being. Because we have to see whether the next issue will arise. If the decision is against you, then the issue will be whether that excess drawl has been made due to any fraud or misrepresentation on your part. Anyway, how much time do you want?
2 weeks, madam.
Mr. U. Sharma
Lordship, date may be fixed.
has submitted a letter dated 9/4/2025, issued by the Director Secondary Education Assembly, which is to the effect that a committee has been constituted by order dated 16/3/2025 to re-examine the service of the petitioner, and the findings of the had been constituted, and the findings of the committee had been sent to the government by letter dated 8/4/2025 seeking instructions. Accordingly, Mr. U. Sharma is accordingly granted a further 4 weeks time to obtain instructions in this matter. Mr. C. Barwa appears for the point number 3. This is the matter after 4 weeks.
May it please the lordship. Lordship, I am appearing on behalf of Mr. P.D. Nair, my lord. Due to some medical emergency of his mother, he has to take his mother to hospital, so he could not come, my lord. Moreover, my lord, we have filed an affidavit in the IA, my lord. That is also not on record, my lord. So may it be taken up after Bihu vacation, lord.
My lord, I do appreciate the difficulty of my friend, Mr. Nair Miller. Anyway, my lord, the relief which I am praying for by way of the IA, my lord, it is from the government. Lord, I am not getting my salary. Since 1/11/24, I have not received my salary. My lord, the issue is whether we are entitled to get the benefit of the cabinet decision up to 65 years. Now, my lord, one faculty member of Cotton University, one Mr. Wari, he was given, my lord. So there is a stay order by virtue of which I am also continuing. Now, my lord.
Let us wait. Let us wait.
Salary part.
No, it's okay. Let us wait. Mr. Nair is unwilling.
Nothing to do. Here is government will have to pay. Under the statute, my lord, our salary is to be released by the government. I am not seeking any. In fact, Cotton University has forwarded my case. I am no relief against Cotton University, my lord. We are seeking relief against the state government, where state government is taking a vacillating stand. Now they are neither saying no.
Have you filed an affidavit?
Yes.
We have to file affidavit.
Huh?
The government has to file affidavit.
You filed an affidavit?
No, my lord, every time, my lord, this notice was issued on 30/10/24. Now we're in almost end of April. My lord. If not, my lord, arrear, at least my current salaries will be paid, my lord.
But the another incumbent, my lord, of Ganesh Wari, who was holding the post of up to 60 after 65 years. Another petition is pending, my lord, because his post.
We'll take it up after vacation.
Immediately after vacation, in the meantime, I'll.
If you file within
My
that time.
learned friend is making a submission. I know government takes time, my lord. But I'm only on that salary part.
No,
I
maybe,
know the.
maybe.
I know, my lord,
If you're entitled, you'll get everything.
No, my lord, the issue is, my lord, I am a professor. I haven't got my retirement benefit. I have attained 60 years, my lord. After, my lord, 30th October, I'm not getting anything. Now it is 6 months. How do I survive? I haven't got anything. It's not that they're paying provisional pension or anything to me, my lord. So
Not-
did they
not
pay my
5
current
months.
salary?
My lord, the issue is, my lord, whether his service, the service of the petitioner will continue after the age of 65 years. We are, our
Up
stand
to
is,
the, up to the.
yes, my lord, up to the 65 years. Our stand is that the retirement age is not 65 years. Before that, he
It's
is
60
retired.
years.
Yes, my lord. Now, at this stage, if the salary of the petitioner is paid, my lord, it will amount to.
His actual date of retirement is,
No,
according to you,
if it is 60
60.
years,
60
then
years.
I retire on 30/10/2024. Whereas a person similar like me, they were given extension and they are working, my lord.
and you're working.
Yes. Now, my lord, government is not denying my right also. They are just taking a vacillating
Let
stand.
him take a decision. Let him take it.
No, my lord, at least they should consider paying me, my lord, my salary, my lord. Or how do I survive, my lord? There's nothing for the last 6 months. I have not got anything. That's what I'm saying, my lord. Well, kindly consider
How much?
that.
Huh?
Paying salary at this stage, my lord.
Anyway,
when the issue-
let us wait.
regarding
Let us
the-
wait. Right.
Then, my lord, may I pray, my lord, on 23rd, let the matter be listed,
Okay.
on which that lordships will decide my IA, my lord.
Okay. Right. Adjournment prayer has been made on behalf of Mr. P.D. Nair, Learned Standing Counsel for the Cotton University. On the other hand, Mr. K. Chaudhary, Learned Senior Counsel for the petitioner, submits that the petitioner has not been given his salary since November 2024. And as such, a decision needs to be taken in the IA. IAC 762/2025. Full stop. The issue pertains to whether the petitioner should have retired at the age of 60 on 31/10/2024, or whether he will continue to be in service till the age of 65 years.
In terms of the cabinet decision of this state cabinet.
In terms of the cabinet decision of the cabinet. In terms of the cabinet decision. List the matter on 23rd. On which
Okay.
date? Huh?
Can be last week of April, my lord.
No, on to 23rd.
23rd.
On which date an attempt shall be made to decide to take a decision on the
If not, my lord, if not the whole petition, then my lord, that my interim.
IA.
Yes.
IA 762 of 2024.
Okay. My lord, in the meantime, this vacation will come, my lord, that's why I'm speaking, my lord.
That is why you are going to do work. You've got so much free time. That's what we do. Holidays, we do work. All our JV matters, we finish off.
My lord, I can prepare, my lord, but the thing is that I think the government holiday will be there, my lord.
No, but the view holidays will be over. You will, now today is the 9th, my lord.
Waiting and.
24th. 24th.
Okay.
24th. One day. Mrs. C. Barua appears for point number. Item 17, Mr. Your case has not been decided by the SLC.
No, my lord, it was pending, my lord, but it was not tagged, my lord. It is
Okay, his name, for the petitioner. And who's for the respondent?
I appear, my lord, for.
G. Pegu for?
Two and three.
Huh?
2 and 3.
2 and 3, Ms. S. Chutia for?
1 and 4.
1 and 4. Same. Dispose of. That compassionate. 18, 19, 20, same.
20,
One item is a bit different, my lord.
I know.
not 22, 22.
22 is slightly different.
No,
They have not challenged that OM.
not 22.
20, I think. Oh, yes, 22, my lord.
22 is not done. 22.
Not challenge.
22. I think it's challenge. They challenge
Challenge, my
everything.
lord.
Only thing is that
That
in
was-
22, it was the writ petition has directed They have come earlier by way of a writ petition, and they have directed the DLC to reconsider. DLC is not reconsidered.
Yes.
That's the only difference.
Same one.
22, same thing, but I'll make a slight modification because the facts are slightly different. Out here, your thing was rejected. Then you came by writ petition. This court directed that it should be considered, reconsidered. You have not reconsidered.
Maybe, my lord, if not considered till date.
Naturally,
Naturally.
I won't say that. If not considered, if it's already considered, you see, because there's no challenge. Okay. Just say if not considered. In all the writ petitions, you can say, if not considered. If not considered. That are correct. You give it to. Just do normally.
Only, my lord, Supreme Court judgment may be applied in the appropriate case, may be applied, my lord, in the appropriate. Otherwise, they may blanket application.
They will do that. That is most probably 100% they will do it.
Kindly, my lord, if your lordship please, my lord, may apply, my lord. In the appropriate case, they may apply.
No, I will not. That will be bad. That will be not good for you, in fact.
Yes.
Because they will use that in all. They say that if this can be applied here, why not here?
Perhaps, my lord.
It covers, that judgment covers a lot of situations.
May it be pleases your lordship. Here your lordship on instruction has been received, your lordship. Your lordship, wherein it has been stated that earlier your lordship, one writ petition has been filed before this honorable court, petition being number 2426/2021.
Yes, page
And
66.
against- yes,
Page 66.
And
It is there.
against that, your lordship, SLP has been filed.
Okay.
So, your lordship, I would like to place this. And another pertaining.
SLP, why not division bench?
No, but they have, earlier they approached, my lord. Even though they dismiss their appeal, my lord.
So your lordship, SLP has been filed, your lordship. And another pertaining to this, the present case, your lordship, there is an opinion that the post that was created along with other posts of the said school, which I would like to place it, your lordship. I will beforehand.
You
your
have not
lordship.
completed your sentence, madam.
Yes, your lordship, I will again, your lordship, start it, your lordship. Second paragraph onwards, your lordship. The department, I would like to read it. The department is of the opinion that the post that was created along with other posts for the said school as a normal practice. No post was created in the name of the petitioner Bilayat Hussain, which is the present petitioner, in the year 2013 under the Provincialization Act 2011. Therefore, any matter of provincialization after the Provincialization Act 2011 being abolished automatically falls under the purview of the Provincialization Act 2017, which is the present enforceable act, your lordship. And thereafter, fourth line, your lordship, fourth paragraph, I would like to read, your lordship. The next date of hearing is fixed on 9/4/2025. As such, department in compliance had moved to finance department for concurrence of the petitioner, for concurrence of a proposal submitted by DSC that was submitted by Director Secondary Education, Assam, for provincialization of service of the petitioner under the provision of Provincialization Act 2011. With the petition, with the concerned file number so and so on last 7 April 2025 as submitted by the DSC Assam, your lordship. Thereafter, your lordship, in this regard, it is again reiterated that although a post was created as a normal practice and the filing and the filling up of the post was kept in abeyance due to legal dispute. However, the said post remained vacant under the purview of the abolished act.
Only Madam, they have sought legal advice from you, from the standing council,
Your
as
lordship,
to whether SLP should be filed.
and your lordship, this
That,
your
that,
lordship,
that, that does not mean that SLP has been filed.
then your lordship already that on the next dated, that is paragraph 4, your lordship, hearing 9-4, the department has compliance and moved to the finance department for concurrence of a proposal submitted by DSC. It was forwarded to finance, your lordship, under the provision of Provincialization Act 2011, although the file has already been moved, your lordship, on 7th April 2025. So it was the
Yes.
part of the finance, your lordship, whether
It is very unfortunate on my part to say that it is just a skin saving exercise.
Huh?
It is unfortunate on my part to make a submission. It is just a skin saving exercise by the department, my lord. At the last hour, my lord, they have sent a proposal which we have returned immediately. It was not in compliance with all the required parameters. No approval of the higher authority was taken. No, my lord, the issues were not detailed out. Immediately thereafter, we have returned it, my lord, to take approval. Only day before yesterday, my lord, this proposal came to the finance department. And my lord's order was dated 19th of March 2025, last order, whereby lordship has issued a picture.
I have filed a affidavit, my lord, regarding similar situated. Yes, my lord. 4/4/2025, my lord. I have annexed the documents, my lord. Court
Just a
order
minute,
and
just a minute.
They have enclosed the entire bunch of documents, my lord.
So subsequent to this order passed in 2019, judgment and order, nothing has been done.
Because, because the entire writ petition is founded on the speaking order My lord, that is available at page 62 of the writ petition. Yes.
The directors.
Yes. Not
So
direct.
that has remained.
That is the foundation of this.
Who said that it has gone to division bench, this case? This
Yes.
case has not gone to division.
Yes.
It has gone.
Uh,
Where is the division bench order?
Let me there appeal, my lord.
Huh? Where is the division bench order?
My lord.
Why isn't it in your writ petition?
And there is one another aspect of the matter in provincialization issue, finance has no role as such. Now, there are cases that, my lord, in the earlier round of litigation, this honorable court has issued a mandamus that you consider under the 2011 Act. 2011 Act is no longer in existence. So they will have to take the call, my lord, whether.
They are not taking the call.
Yes, that's what. At the last moment, my lord, day before yesterday, this proposal was moved to the finance department. Immediately on examination, it was found that it is neither here nor there. So it was
Your
returned.
lordship,
So my instructions are clear.
as per my instruction, your lordship, which I already placed, your lordship, the second paragraph, your lordship, which I already read it, that your lordship, in the practice area, your lordship, petitioner name in the year 2013 under the Provincialization Act 2011, no post has been created in the name of the present petitioner. And your lordship, department has no objection if it falls to under Provincialization Act 2017, your lordship.
See,
Instead of
it is not, you see, when this court has passed an order, we are not bothered whether you are happy with it or not. You have got to either accept it or you can challenge it. You cannot say, you have done this, but we will accept it if you do this. You cannot dictate to us. I'm going to, then I think I'll have to take up this so moto contempt against thing, and I will make it sure that who has to, this director and the secretary.
Lordship will file
Sixth instruction, your lordship, as per finance, your lordship, instruction received today itself, your lordship.
Maybe.
Your lordship, so I may give some time to communicate that proposal has been
2019, madam.
rejected, your lordship.
6 years have gone by.
And Vilayat Hussain is filed on your lordship 6741/2024. So your lordship, your lordship.
Madam, he's done it because the 2019 order has not been complied with.
Some time may be given, your lordship.
We have given you 6 years. How many years more do you want? This
Last chance, your lordship.
Last chance for what?
Last chance, your
I'm
lordship.
taking up this contempt now.
Your lordship, last
So there,
chance, your lordship.
and it prima facie appears as per this that you have committed contempt.
Will make.
You have made your contempt. I think you see sometimes this is clear. There's nowhere to hide.
One last chance may be given, your lordship, if they doesn't comply with the order, your lordship. Your lordship.
We are not doing it. Why? You see what Mr. Pujari has said. Finance is not required for this provincialization. Correct? So,
That proposal was also incomplete. There's a detailed instruction, madam. The proposal was incomplete, madam.
Last chance, your lordship, for the end of the justice, your lordship.
and I think you have got to take it serious. Now I think this court, unfortunately, maybe will have to take a very, very serious issue. Maybe one case of sending someone to jail, of imprisonment, then they will learn. This is not the way you do things, madam.
I already communicated, your lordship.
So let them face the music. Let them face the
Instruction
music.
has received, and finance part, your lordship, we are not aware. Today itself, your lordship.
Look, the finance department has said.
Yes, your lordship.
You're very clear.
Come to our knowledge, your lordship, today itself, your lordship. To that, your lordship submission, your lordship, I may allow to give in some time, your lordship. For the end of justice, last chance may be given, your lordship.
For the ends of justice or for the chance of making it correct? For the ends of justice, you're not doing anything. You're running away and ensuring that justice is not done. That is why we're having this case.
Kindly grant us last chance, your lordship.
For what? For to do justice or for not doing justice? When the court orders, they're directing you to do something and you're not doing it. They are asking you not to do it. Is it for justice when you're not doing it? Why do people come to court?
Finance has cancelled it, your lordship, that is not.
Finance cancelled because they said it is so incomplete. And that it is
thing,
just
your
for
lordship, I am not
show
aware.
that you have submitted. And plus you have not done it as per without giving necessary particulars. And they have got nothing to do with it. He just said, I'm recording there also. He has got nothing to do with it.
After Bihu vacation, reopening.
I think they should go before Bihu, spend there huh? Then they will learn. At least one of them should go. Who? I will call the day after tomorrow. Let them come here. So that just before Bihu they can go. It's not done, madam.
Friday, your lordship.
Locking a cancellation Friday locking, I'm getting something from the secretary. So far the cancel from the finance part, we can need to know on the locking. On Friday locking will pass many orders.
Look, Mr. Counsel, I do not know what advice you all are giving your clients. This is an order passed in 2019. And that was in January 2019. Now it is April 2025. 6 years have gone by. And now only you are taking a decision to go to Supreme Court. 6 years. Only it can be, it doesn't need much of rocket science to guess that you're only doing this to circumvent the orders that might be passed. That also only with an intention to delay.
Friday locking.
Why not tomorrow? Why Friday?
Yes, tomorrow.
Your condonation of delay application has been dismissed by the division bench. You have not put that to challenge, and you want to challenge the single bench judgment. This this is not done. Right. Heard, Mr. A.K. Azad, learned counsel for the petitioner. Also heard Ms. P. Das for Secondary Education Department and Mr.
R. Borpuzar.
R. Borbujari for
Finance
Finance Department. Anybody else?
Respondent 5.
I'm 1, 2, and 3.
1, 2, and 3, and respond number 5. Who is for 4?
4 is the headmaster, man.
Okay, right. The petitioner's case is that the state level scrutiny committee has not considered the case of the petitioner for provincialization in terms of the order dated 17/9/2024. Issued by the Director, Secondary Education Assam, which is to the following effect, huh? This in this order dated 27/1/25, it is there, huh? The italics. The same had been done. In terms of the order dated. Fourteen seven 2024. Passed in WPC 2426 of 2021. No, the order dated 14/7/2021, passed passed in WPC 2426 of 2021, huh? 14/7/2021. Cannot be 14/7/2021. Where is that order? Where is 14/7?
Page 58, my lord.
Huh?
Page 58.
Page 15. Fifteen.
58,
58.
my lord.
It has been done in terms of the order dated 14/7/2021, passed in WPC 2426 of 2021. After giving numerous opportunities to the respondent to consider the case of the petitioner for provincialization, the Ms. P. Das, Learned Counsel for the Secondary Education Department, has submitted a letter dated no letter, no date, no signature.
E-sign is there, Your Lordship. 8/4/2020. Is
Submitted a letter dated 8/4/2025, issued by the Secretary to the Government of Assam, comma, Department of School Education, which is to the effect that the government has taken a decision to prefer a special leave petition against the order dated 14/7/2021, passed in WPC 2426 of 2021. And had thus sought legal advice from the Senior Standing Council, Department of School Education, Guwahati High Court. The letter also states that as the Provincialization Act of 2011 had been abolished, provincialization could only be done under the Provincialization Act of 2017. The letter further states that the department had moved the finance department, the Department of School Education had moved the finance department for provincialization of the service of the petitioner under the Provincialization Act 2011. On, no, Devin, what's next. Mr. R. Borpujari, the learned counsel appearing for the finance department, submits that the finance department has got nothing to do with the provincialization of the service of a teacher. Correct? He further submits that the proposal sent by the petitioner for provincialization of the petition was woefully short on particulars. Correct?
Yes. So the second, if lordship is taking up the second page, my lord,
Yes.
of that, then kindly see, my lord, the first paragraph, the department at the last moment had endorsed the file to finance SIU so and so.
Where?
Yeah, my lord, the second page.
Second page here. Which para?
My lord, the first paragraph, the department.
No, it says here for non-provincialization.
Yes.
There's no the department. What are you talking
Well,
about? That's
fine.
third paragraph.
Yes,
Third
my-
page,
Third page, my lord.
not
I'm sorry.
second page.
Yes, my lord, I'm sorry, the third page. Third page, kindly see, my lord. The
What have I
depart-
said? Further, the department, the education department had endorsed the file to the finance bracket SIU bracket to the department at the last moment, without any approval being taken from the
My lord, the honorable
chief minister
or the department.
or the departmental minister
Yes, my lord.
on the proposal.
Now, my lord, it will also have to, they will also have to take a policy decision. Accordingly, it was returned immediately. Because that act is no longer in existence, so therefore a policy decision has to be taken, my lord.
I don't know.
Yeah.
Whether they take or not, that's. I have next on hearing the counsels for the parties and the documents they have submitted. Come on. This I have one more thing, right? Mr. H. Borpujari has also submitted a letter dated 8/4/2025 issued by the Deputy Secretary of the Government of Assam Finance bracket SIU Department. Next para. On hearing the submissions of the parties and considering the fact that the state respondents have not taken any real steps to implement the order dated 17/9/2024 issued by the Director of Secondary Education Assam, which is in pursuance to the order of this court in WPC number 2021, the 2021. This court finds that the prima facie finds that the respondents are the education, the secondary education department are basically delaying the matter. Thereby interfering with the administration of justice. First up. It has also been brought to the notice of this court that though an appeal had been filed against the order dated 14/7/21 passed in WPC 2426 of 2021. The application for condonation of delay of 617 days in filing the appeal had been dismissed by the division bench of this court on 22/5/2024. In IA bracket civil 1113/2020. Yes, what to do?
Last chance may be given to us, Your Lordship,
For what? What will you do?
to obtain instruction, Your Lordship, as a file has already been returned. We are not aware, Your Lordship. Today, we just came to know that the file has already been returned by the finance.
You see, the manner in which you have sent the file and the manner in which it has been returned clearly shows that the knee-jerk reaction to the order passed earlier. Nothing has, they are really not interested in doing anything. Nothing will happen. Anyway, just right. Ms. P. Das submits that as the files, as the proposal for provincialization of the petitioner has been returned by the finance department. And as the finance department's counsel has submitted that the provincialization of the petitioner does not require the approval of the finance department, is it?
At this stage, my lord.
What do you mean at this stage?
No, my lord, under the statute, my lord, it is not required.
And under the statute, comma, she may be given one last chance to obtain further instruction. Accordingly, leave this matter on 24th.
I'm deeply obliged.
Lordship may retain it as a part of the record.
Huh?
Lordship may retain the instruction as a part
Yes,
of the
yes, yes, okay, right, correct. Give me the stapler. This, Miss P. Das's documents are,
Last thing, Your Lordship.
this part is all right. This part is, the letter dated 8/4/25 issued by the Secretary of the Government of Assam Department of School Education. And the letter dated 8/4/2025 issued by the Deputy Secretary of the Government of Assam Finance Department, Finance bracket SIU Department, are made a part of the record and marked as annexure X and Y respectively.
After the suspension, they have not reviewed the order within period of.
In this case, I have received instruction. Charge sheet was submitted on 7/3/25.
Charge sheet has been submitted
Yes.
after 3 months.
17?
17/3/25. Then he filed reply on 27/3/25.
27/3.
Yes, and the fresh suspension order has been passed yesterday.
What?
Yesterday, fresh suspension order has been passed.
That is in violation of the Chaudhary's case, man. I have annexed a copy of your lordship's judgment at page 41. And from the page 41, and that covers all my cases. Very detailed judgment your lordship has passed. Ultimately, the crux has been.
Where's the crux?
Crux is reflected in the last paragraph, my lord. Paragraph 23. The case of Sundar Division Bench of this court on analyzing the decision of the Supreme Court in the case of Sundar held that unless a review is held within 90 days, an order of suspension, including one issued due to detention of an employee in custody for 48 hours, would not survive. In view of the reasons stated above, this court will review.
That order has already been gone. That order has already been gone.
Has already been?
Yes, that has already been lapsed. The first suspension order. After charge sheet has been filed on 7/3/25. If I'll reply, then yesterday lordship raised order of suspension has been passed.
That they cannot do, my lord.
There is no bar.
Has to be.
No, but just see, let us see what.
Paragraph 23 and 24.
Have you got the judgment with you? Paragraph 23, 24. Have you
Yes,
got it?
In this case, there was no review.
Then?
But here lordship, that has already been left there till we pass a fresh order.
That is a remitted fact.
But you see, 24 says that the initial suspension order is hit. And not sustainable.
Yes, lordship.
The subsequent suspension order, what does it say?
Lordship, because the allegation against the petitioner was against one student has filed complaint.
Yeah, whatever may be.
Charge sheet has been filed.
He might have murdered 20 guys also. That's not the issue.
My submission, lordship, my submission that initial suspension order there will already been lapsed. We have passed fresh order.
Where is the fresh order?
I'll place lordship maybe taken up tomorrow. Because I place all these things.
A fresh suspension order.
Yes, sir. Yesterday. The approval of the executive council.
So he says a fresh suspension order.
Fresh suspension order is also a suspension order only. If a suspension order has been passed, it has to continue. It will continue. It cannot be like that.
Is it a fresh suspension order in respect of a separate case?
Chaudhary case will go.
Is it in respect of a separate case or is it the same case?
Same case. After filing of the charge sheet. No, lots of there is a bar. With that we cannot issue fresh suspension.
This is a new.
Ajay Chaudhary said. Ajay Chaudhary.
There is no bar for you to issue that fresh suspension order has to be in continuation of the earlier suspension. If there is a break.
No, lordship. My submission, lordship. Ajay Chaudhary. I have gone through the Ajay Chaudhary also. Because we have to review within 90 days. If it is not reviewed, then the order is bad. But there is no bar in issuing fresh suspension order.
No, but it cannot. It has, you may call it fresh, you may call it double fresh also. But the fact remains that it has been made in continuation of the earlier suspension order.
That cannot be continued in view of the Ajay Chaudhary because it was not reviewed within 90 days. So that initial order has gone. This is admitted. I am not saying that, but we have put under suspension in the phrase.
Ajay Chaudhary has been banned.
So you say that, okay, so fresh suspension order.
Yes.
So now therefore fresh suspension.
I'll place tomorrow, lordship may take it to
Let him. Okay. Right. The petitioner has prayed for setting aside the deemed suspension order dated 19/8/2024, issued by the respondent number 2, on the ground that no charge sheet / memorandum of charge had been submitted within 90 days, within 3 months, and neither had any review of the suspension order been undertaken within 3 months. On the other hand, Mr. SCKL, standing counsel for the respondent, submits that charge sheet has been submitted. Charge sheet or show cause notice?
No, just.
It's in a criminal case.
No, it's the departmental process.
Show cause notice.
No,
A memorandum of charge.
memorandum of charge. Memorandum of charge.
Submits that a memorandum of charge had been submitted on 17/3/2020. 7/3/2025. And a reply to the same has been made by the petitioner on 27/3/2020.
Lots.
He submits that no review of the earlier suspension order dated 19/8/2024 had been made. Full stop. However, the respondents have issued a fresh suspension order. When?
Yesterday.
On 8/4/2025. And no, full stop. He further submits that the judgment of the Supreme Court in the case of Ajay Kumar Chaudhary versus Union of India,
Yes.
or Union of India versus Ajay versus Union of India, 2015, 7 SCC.
Thank you. 2015 7 SCC case 291.
291 does not bar the issuance of a fresh suspension order when no review has been undertaken with regard to the old suspension order. This is the matter. Oh.
2 p.m.
Huh? Day after?
Friday, let's see, I'll not, I think.
Tomorrow. Item? No one appears for the petition on call. According after 3 weeks.
26.
May it please your lordship. Lordship, as per the office note dated 7/4/2025, notice upon respond number 3 is service notice is awaited, lordship. Service report, we have sent notice, lordship, as per the last order. And also we have implemented the new respondents. Secretary.
Notice has been issued on 3/4/25.
Otherwise, lordship, 6 and 7, we have served copies and I think instructions have been received.
Has notice been issued to the respondents number 6 and 7?
Lordship, we have, lordship was pleased to implement them parties on the last date and we have served extra copies, lordship. According they have appeared.
We have received the instruction, but that is.
For?
6 and 7.
For 6 and 7.
Yeah, for 6 and 7. Okay, right. You have received instructions, how much time?
We have received the instruction, my lord, but that is not complete, my lord, because they say the investigation is under investigation.
Investigation is under investigation. How can it be?
The process, lordship, they have stated in the. Otherwise, lordship, my name is not in the FIR nor in the charge sheet, lordship. May I take it the matter.
So,
Process of scholarship, my lord, the headmaster has a role, main role, my lord. So now that role of that person, my lord, under an investigation, it will take some time.
Okay, right. As per office notes, notice was issued to the respondent on 3/4, respondent number 3, on 3/4/2025. As such, awaits service report. Mr. G. Pegu, learned counsel for the
Respondent number 6 and 7.
respondent number 6 and 7 submits that though he has received instructions, the same are inadequate. And as such, he has asked for clarifications. Accordingly, leave this matter after 3 weeks.
After 2 weeks, lordship.
After 2 weeks.
Well, name of the GA Assam may be shown in the court case.
Registry to reflect GA Assam in the public.
27.
Much obliged.
In item 25, I was waiting went to the other court for my another matter. Item 25. So my
Item
name will be
25.
reported, item 25. And matter may come up for admission, Lordship. Service, I have filed my
It
reply.
is, okay, right, item 25.
Yes, Lord.
The affidavit is ready.
Lordship, I have filed my affidavit.
No, you have to, unless you file, the case cannot start. Respondents have filed or not?
No.
Let them file. Okay, just don't say,
It is,
just say petitioner's counsel is present, that's all.
since 2018 it is pending. So
This is the matter after 3 weeks to enable the respondents to file their affidavit.
And here's the last one.
You were not here, Mr.
no,
Nandan.
because
Now I, no,
Only because 2018 matter, they are.
you should have been here.
Actually, in this case, I have filed affidavit in opposition and one IA for vacating the stay also. And as per last order.
The order, what's the order?
There is a stay order.
And as per last order of your lordship observation, whether he can be transferred in any other place in Assam. The department is exploring the possibility of that, whether he can be transferred to Shillong or Aizawl lordship, not in the Assam. So if my learned pen is.
No. What about, have you approached the court
No.
No, Lordship, the
for changing the bail condition?
proceedings are stayed. Proceedings of the court are stayed. And
Maybe, but then you can always ask the court, who stayed by whom?
by the Honorable High Court. So proceedings are stayed. So
Proceed, you see, there is no bar for you to ask the High Court to allow you to move an application for change, for modification of the bail condition. That's all.
Lordship, that apart, what I have submitted on the earlier occasion is that they had transferred me to Bangalore. If Lordship allows me to show as to that it is their minutes, their review committee which has said and that I ought to have been in Guwahati only. After 3
No,
months.
I'm not on that.
The
I don't know.
transfer of the-
You want a particular place.
No, I do not want any particular.
Then how is it so difficult for you to file an application?
Lordship, I've been transferred to Bangalore.
I know.
Bangalore is.
That's why please ask the High Court in that criminal case to allow you to move an application for modification of the bail condition before the concerned court.
No, Lordship,
Who gave you the bail order?
Lordship,
The CBI
Who?
court.
the
lordship.
CBI court.
That's what.
CBI
So you have got to go to the CBI court and ask for modification. Now, if the CBI court proceedings have been stopped by the High Court in a criminal case, you go in with an application in the criminal case to this High Court and ask the High Court to allow you to move an application for modification of the bail condition.
Lordship, to that I will respectfully submit, Lordship. I have challenged this transfer order on 2 grounds. First, my ground is that I have not been, there is a bar by the CBI court. Second, as per the rules, they cannot transfer me to Bangalore. When there is a transfer policy.
No, this is not, the normal rules of transfer will not apply in cases like this.
No.
You are under a cloud right now.
That's what, Lordship. Now again, there is a CVC guideline where it says in para 4.6, it clearly mandates that as per the procedure laid in case of allegation of misconduct in the borrowing organization against an officer who was on deputation to that organization and has since been repatriated to his parent organization, the same is to be inquired by the CBO of the borrowing organization. Here, this.
I won't go into all this.
Lordship, in this department, there is nothing. No misconduct was in this department.
Maybe.
So if Lordship, if there is no misconduct, now why is the person transferred, Lordship? In my respectful submission is that he does not do anything in the department, so that he does not anything, the department proceeding, he is not influencing any department. Now, I was placed under suspension for a misconduct, alleged misconduct in the borrowing department. That's why CVC has given us specific guidelines saying that the borrowing.
Are guidelines enforceable?
Lordship, this is a cyclic, it's a CVC guideline and this has been followed.
No, I'm asking you, is it enforceable in a court of law?
Lordship, to my respectful submission, it is for.
What does the Supreme Court say, whether guidelines are enforceable or not?
It's a circular, Lordship.
So whether it is enforceable or not?
Lordship,
now again, Lordship, to that I'll respectfully submit. Now, if the borrowing department, if the.
No, I forget about borrowing and non-borrowing. My question is a guideline or a circle or whatever you may want to call it, is it enforceable in a writ proceeding?
Lordship,
What does the Supreme Court say?
Lordship, to that effect, the authorities, I'll have to place, Lordship, you have to give me a time to that thing there. But to my understanding, limited understanding, Lordship, is that here when the departmental proceedings are being done, again, the law says the interference of the court should be minimum in regarding departmental proceeding, there is no dispute to that fact. What I'm submitting, Lordship, is that.
Well, anyway, I'll tell you,
Now-
guidelines are not enforceable. Okay, one. Now, leaving that aside, what he said has some force also, in as much as his misconduct, alleged misconduct, was done in the borrowing department. In the parent department, he has got no issue. If there is no issue in the parent department, why are you transferring him out? How can he? How will he influence the DP or the investigation that is being carried out pertaining to the borrowing department which he has left?
Lordship,
if just for a moment.
Just a minute, I'm asking him.
Lordship, memorandum of charge has been issued by the IGNO.
By IGNO.
IGNO.
Ah.
And so
He's working where?
He's working now under IGNO.
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 And the misconduct was done where?
Where he was deputed at NAC, National Highway Authority of India. And that misconduct was accepting ratification, Lordship, under Section 7 of the PC Act. So for that, Lordship, IGNO is also competent to inquire that misconduct, because taking
His substantive post was there, yes.
And to that I'll submit that I had given my reply with the CVC guideline. In 24, they had issued me the memorandum of charges. Till date, they have not issued any presiding officer or anything. Now they have not gone ahead with it. Regarding the.
So basically, you don't want to go out of Assam, and that is why you're not asking for.
No, Lordship, it is not me who is saying. Lordship, it's their department only. What has happened? Why this thing came? Basically, the reason behind that as to why this thing came and suddenly they want to send me to Guwahati. There's a reason behind it.
Bangalore, you mean?
Bangalore, sorry. Bangalore, there's a reason behind it. Lordship, if Lordship is just to take page 108 for a moment.
No, you see, forget that.
No, what had happened is that in the minutes, when there was first I was placed under suspension. There was a review committee meeting. In the review committee meeting, there is a specific finding of their committee saying that since there is a case pending in Guwahati, he will be posted in Guwahati. Now what happened is that he had challenged the transfer order.
Who had challenged?
The petitioner had challenged the transfer order in the earlier round of litigation. In the earlier round of litigation, when it challenges transfer order and when they did not review it within that 90 days, then this transfer order was, they had a review committee meeting after the period of expiry of 90 days. Now what had happened in that thing, that the transfer order was quashed. In the transfer order, there was a line, which line says that he may be transferred as per the extant routes. Now what they did is that they took that line as a directive of the Honorable High Court, because if the impugned order is taken into the in compliance of the order, so they took that line as per extant rules. It was given as per this Honorable Court said this transfer order is bad. So as per extant rules, if you are allowed to do transfer or whatever, like as per the extant rule. Now his service condition is bounded by a rule, wherein says the section officer has to be from the regional office. Secondly,
no, you see, the normal rules of transfer won't apply to you.
No, that again, regarding the section officer, which I have been the substantive post, which is my post, that is in Guwahati, it is still lying vacant.
Maybe.
So what?
If there is a vacant post in Bangalore, you go there.
No,
if they don't want you here.
I am challenging on that point that when the
Supreme Court in Ajay Kumar Chaudhary has allowed transfer of a person to any of its offices, then you see the question of the guidelines being followed, the circular being followed, cannot be applied to you. You have been reinstated under a cloud.
Lordship,
That's all. So
that again, Lordship, now, Lordship, what has happened is.
no, why are we going to merit?
So let them, let the affidavit opposition come.
Why affidavit? Why shouldn't I dismiss it and then you go to the directing you to go to the criminal court to file an application therein for modification of your of your bail order to allow you to file before the CBI court. Modification, you ask for a modification there.
Lordship,
And then
I respectfully
or
submit, Lordship.
but you don't want to go. Basically, that's your case.
No, Lordship, Bangalore is, because once the trial starts, if you have to come from Bangalore to Guwahati for every date, which every month there are 2 dates. From Bangalore to Guwahati.
No, you see, this is still charge sheet has been filed or not?
Charge sheet has been filed.
Charge sheet has been filed.
Charge sheet has been filed. In fact, it is fixed. It was fixed for charge hearing.
No, higher investigation is going on.
No. The charge sheet has been filed. It is fixed for charge hearing. At that moment, one.
But you have stated the proceedings.
Yes. No, I have not stated the proceedings.
Then you have, who has gone to the High Court?
The another accused. There are 8. I'll just give a what had happened, Lordship. There were 12 accused. One accused was discharged in the High Court only.
So you'll work here.
My
petitioner is urged us. I don't know whether this urges us or not in that case.
No, that is, I am representing a different accused.
No,
in my personal capacity, I can represent 2-3 accused. That does not mean that the petitioner is GR Infratech.
GR Infratech.
GR Infratech.
I think I did this GR Infratech or some case I did earlier. No.
Lordship, GR Infratech, no. Now again, Lordship, I'll just give a brief thing. Lordship, there were 12 victims. My boss in the borrowing department, he was discharged, Lordship. My boss, this alleged thing, my boss in the borrowing department, he was discharged. He was discharged.
Why should I go into those issues, whether they are discharged or not discharged?
No. Lordship, what I'm trying to impress, that in a charge sheet, the allegation was taking money by the officials of NHI. I was in the borrowing department as an official of NHI. When the top boss was discharged, then GR Infratech approached the court along with.
Where is your bail order?
Bail order is 5th page
84.
11 is 96.
And the relevant portion is
96.
It starts from 95. And my offending clause is, which is point number 5 in space number 96. That the Lordship has got it.
Until completion of further investigation.
No. That was the bail.
So if you see, now if it is investigation, charge sheet has been filed. End of investigation.
No, Lordship. What happens? Lordship, there is a procedure. No, Lordship. I'll show from the record. Once he got this bail during investigation. Now, once the investigation was completed, then they were called for the charge sheet. Their appearance as a charge sheet. Because
they appear as a charge sheet.
So I had to go for a previous bail. So the previous bail conditions comes into thing. Because in a
what previous bail? Where is the previous bail?
This is the previous bail. Lordship, what happens in a criminal trial? To my respectful submission, in a criminal trial, there are 3 stages: investigation, trial, and appeal. Now, what happens is once
appeal is a different thing. Appeal is after.
Yeah, that's what 3 stages I'm talking about. So here, what happened is that I got bail during the period of investigation.
Correct.
So
there is no bar. I can clarify that there is no bar. Though. You see, I can clarify what is an investigation. There's a decision made. Just give me the thick. There's a book at the back, in my chamber. Yeah, I can clarify that. There's a decision by a division bench of this court as to what you mean by investigation.
Yes, Lordship. There is So now that investigation is over, the filing of the charge sheet.
This does not bind you at all.
No, Lordship. I have to then go on a previous bail until and unless my bail conditions.
No.
Bail conditions are modified.
Sorry. I think you are mistaken. Their condition need not be modified. Excuse me. This is the problem with being old school. I have to look. look
No,
where it is, I don't know.
And Lordship, then why I'm saying Lordship, what had happened to one of the co-accused after the allegation, what had happened is that he had not informed the court, and subject to the thing that is, the lawyer had advised anyone that you can go now, there is no nothing as such, because he went there and then he filed an application that he has been out of state, and then the co-accused was almost put behind bar by the court there. That apart, what happened is that each time these people have to go outside, after the charge sheet was filed on.
This court will clarify. Then you can say, look, this is the court, this is the order passed in the writ court, that they shall not leave the jurisdiction until completion of further investigation does not bind you. We'll clarify that.
Lordship may pass any order that's Lordship, but
No. If because the entire case is based on this, that the bail condition does not permit you to leave the jurisdiction of the CBI court.
both. And the second is that the rules does not permit.
Okay, rules does not. That
That is
also we will clarify.
The rules that also not permit regarding is
that also will clarify.
Okay.
Show me the rules. Let me see the rules.
It's here. I have given.
Where?
It's
Page?
next. Lordship may take page 118.
118. Yes.
Lordship is titled as Indira Gandhi Open University Non-Academic Employees.
Yes, yes.
Recruit. Lordship may come to page 119. Transfer liability.
Huh?
Transfer liability, page 109.
Transfer.
Number 13.
These are not made under the page 119.
Number 13.
13, yes.
Transfer liability, Lordship.
Yes.
As a general policy, all employees will be liable for transfer from anywhere in India. However, employees may be retained subject to overall pension strength of the regional centers headquarters. Promotion to group B and A shall be with reference to the vacancies at the headquarters regional centers taken together, and promotion will be effective from the date of assumption of charge at the place of work. The officials recruited specially for Northeast and also regional centers, Jammu, Srinagar, and Port Blair shall serve the regional centers up to the level of section officers or equivalent. So my respectful submission is that I am a section officer. When the rules say, now these rules
are made under what provision?
this they have to clarify because it does not have any.
It's not a rule.
It's and Lordship, what would be this then?
I know it's a guideline.
No, it's Lordship says it's a rule, recruitment rules.
These rules may be called, you may call it anything, but unless you can show that it is a rule.
Lordship, then because they have
I may call myself the principal of some school, but
yes,
you'll say
there
unless
has to
you
be a
can
source of
show.
power.
So,
There has to be a source of power, which and Lordship is saying is the source of power of taking this rule. Now, regarding this, obviously, this question has not come, and they have to also say as to what is the source of power.
it is not your case that this is a statutory rule. In your case was that this is a guideline.
No, Lordship.
That is why I had said whether I had asked you the question, specific question as to whether guidelines are enforceable.
Lordship, that I respectfully submit. Lordship, if these two queries have come from Lordship, I'll satisfy.
No. The queries, the queries have. One query has been answered. Page 96 has been answered.
That regarding
investigation.
Investigation part, Lordship, as per Lordship, Lordship has expressed the view that since it is still investigation, the condition does not remain.
Correct.
Because why Lordship, what happens in the criminal proceeding, after the charge sheet is filed, we go there, we give an application saying that we may be allowed to remain on previous bail. And that application is allowed.
Previous bail meaning?
Previous bail meaning the bail that was granted by during investigation. Now, Lordship, what happens is that during investigation.
This is during investigation.
I'll just clarify this thing, Lordship, allows me to think. During investigation, I might be granted by the court of the first instance. That means it might be the ministerial court. In this court, it is a CBI court. I might be granted bail by the higher authority.
You see, Mr. Counsel, when the court says that you shall not leave jurisdiction of the court until completion of further investigation, it clearly means that the investigation was not complete at that time.
Lordship, I have an answer to Lordship. What has happened is that till that I think the CBI charge sheet will be helpful. I'll place this.
No,
Lordship. Regarding the
if you say that there is an earlier bail order, show me that.
This is the only order.
Then end of the matter.
No, Lordship. Now, if Lordship has taken that part, again, I'll say Lordship has said that.
Okay, what is that thing you have in your phone with regard to investigation? You said there's some judgment you have in your phone.
No, I was searching. I'll give the
I can find, only it'll take some time.
I'd like to clarify. Charge has been filed by the CBI. Why? Because they wanted to keep the accused within 90 days, but that's why they have said there is further investigation also. Then this bail condition will remain. If Lordship has come, then I will bring the charge sheet in on the next day.
You said that they charge. Look, I believe you totally.
No.
100% I believe you that they have filed charge sheet. You said it. And then you said now is the stage of framing of charge.
At the time of framing of charge, this stay order was done.
Framing of charge stage. So charge has been framed.
No, it has not been.
charge is going to be framed.
Is going to.
Correct.
But the charge sheet of the CBI says there is further investigation. If losses, that part has to be looked into. Then the charge sheet, it says the part charge sheet has been filed. Further investigation is also there. Then this bail condition will still remain.
I will clarify that.
That's what I want. Then I'll bring the charge sheet on record also.
Don't have to bring, I can dispose it off.
Well, an opportunity may be given. Let the AI come. I'll file a reply and then on merit anything, Lordship, whatever decides on merit can be decided. Because here,
Now you see one thing. Nothing is happening in the criminal case because you have already stayed the proceeding.
not me.
One of your friends.
Maybe counsel.
Counsel.
He'll pay, he'll
Ah.
counsel.
So nothing is going to happen. So the only thing now what remains is that if you are posted here, you have won the case. Because that case, that stay, when it will be lifted, we do not know. And
Lordship,
everything has been stopped.
as he had submitted
Page,
in the
page
first
48, Lordship, one, replying his query. That Rule 13 is a general rule. And page 48, Lordship, is offer appointment. Lordship.
Ah.
And I am, page 14 and 11, Lordship, clause 8. You will be liable to serve anywhere in India and your service are liable to transport anywhere in India. And he, after acceptance of this offer appointment, he has been appointed.
To that, I'll reply, Lordship, is that whether an offer of appointment.
Your name is Deepak Das. This offer of appointment is given to you.
Yes. To that, I'll satisfy Lordship is that whether an appointment override now the rules that I have shown.
The Supreme Court judgment will override your circular.
Yes, Lordship, Supreme. Now, again, a judgment has to be looked at the fact of the circumstances. that
I have
have been-
looked into it.
So, Lordship, what I respectfully submit is that in the Supreme Court judgments where they are talking about transfer, the reason behind it is that the person should not influence the departmental proceeding. That is the clear. Now, when this person has done an alleged misconduct in NHI, which is the borrowing department, I ask myself this question, Lordship, which officials of IGNOU will influence in the department? Which official I'll influence in IGNOU for a deed for which has been done, alleged deed which has been done in the borrowing department? That question, that part I know has to be because Supreme Court.
Questions though you'll have galore.
So Lordship may, because here again he has given a thing that he might be transferred to even Shillong or Idol or whatever within this. If that be so, because Shillong, if Shillong is given to me, I can at least come for the trial because what trial start because this anytime the
So you are considering shifting him where? No.
That Lordship has the person observed that whether he can be transferred within
transfer
Assam.
Assam or not. They said
To that
Shillong or Idol.
within Assam, it is not possible. We have another RT in Idol and Shillong. We can explore.
That's what
Only-
Let him think of Shillong because one thing is that for trial,
Yes.
he'll have to come.
trial I have to come.
But he has stated, so we don't know.
No, I have not stated that. The other accused have stated, and so that way the other. Let it come after we go with the instruction, clear instruction if they are willing to do it. Then in the meantime, the affidavit opposition and the IA for stay vacating may come and then we'll dispose, everything can be disposed of. If that is, if they are not willing to or whatever.
Okay, right. The petitioner. Where is that order transferring you? Page?
Order of transfer, Lordship. First order of transfer was 14/3/24, page 110.
Yeah.
Then a modification was happening to 12/7/24. Because after the first.
Page.
110 is the first order.
The second one, the latest. Any other transfer order, that's all.
No, then there on 12/7/24, there was a modification to the transfer order.
To what
To the extent that you go and go to the.
No, it is not a modification. It is just he highlights the representation and the representation was disposed of.
Okay.
Rejecting his
So this Page 110 is the
110 is
transfer
the
order.
order.
Okay, right. The petitioner is challenging the office order dash 169 dated 14/3/2020, which has been made in compliance with the judgment passed by this court in WPC 3998/2023. Whereby he has been transferred and posted at the regional center, Bangalore. Where is this 3998? Let us see. Where is this 3998?
Page 26.
Page 26. Achha, this one order, office order 169, page 110.
Order
Huh?
of 3998, Lordship. That
Page
is
90? Huh?
Page 100, page 97. It starts from page 97.
The order dated 15/23 passed in WPC 3998/20.
And the relevant part is 102.
States in para 12 and 13 as follows. Page 100. Okay. Para 12 as follows. Next part. The petitioner's counsel submits that the impugned order dated 12/7/2024. No. Dated
14/3/24 and 12. I have
14/3/2024 cannot be applied to the petitioner in view of the petitioner's bail condition stipulated in the order dated 14/9/2022 passed by the special judge, passed by the court of the special judge, CBI, Assam, additional court number 2 in Miss CBI case number 19/2022 arising out of special case number 05/2022, wherein it has been recorded at 5 at para 10 bracket 5, Roman 5 small, as follows. Inverted commas, that the accused / petitioner shall not leave the jurisdiction of this court until completion of further investigation, if any, without prior permission of this court. Next paragraph. The petitioner's counsel submits that a charge sheet has been submitted in the above case and that
because if further investigation, it's written in the charge sheet, not my.
submits that a partial charge sheet has been submitted in this case and that the stage of the criminal case is framing of charge stage. Is at the stage of framing of charge. Pusta. Next paragraph. The petitioner's counsel submits that in terms of the guideline for transfer under the Indira Gandhi National Open University IGNU, bracket IGNU. Official special clause 13 provides that officials specifically recruited for the northeastern region and also for the regional centers of Jammu, Srinagar and Port Blair shall serve the regional centers up to the level of section officer or equivalent cadre. The petitioner's counsel submits that the petitioner still being a section officer, he cannot be posted out of the northeastern region. So you post him somewhere else, northeastern region, he can be posted.
Yeah.
But regional center, I think, will be here only, in what?
Regional center.
Where?
Regional center is Guwahati.
Next para. The charge sheet having been filed, it appears that investigation is complete. And there is nothing to show that a guideline is enforceable in a court of law. So why are we adjourning the matter?
Because Lordship allows me to satisfy that these rules are statutory rules. These are statutory rules, and regarding the charge sheet part, whether the further, because it's a submission I have made, it's only a partial charge sheet. I will show that it's a further investigation still there as per the secret.
Acha, one more thing, you're right. The petitioner's counsel further submit that the criminal proceeding before the CBI court, Guwahati, has been stayed in view of one of the co-accused having approached this court by way of
a criminal petition.
Criminal petition number
1203/2024. That order I have.
How do you call it? Criminal petition?
Yes, criminal petition. That order is before you.
Where? Page?
No, I have just.
Okay, this one.
That
Oh,
one.
yes.
Yes.
1203/2024. White order dated 16th of 20. So what is there to show? Acha, okay, right. The petitioner's counsel is given time to show that the rules for transfer are a statutory rule and that the investigation
Still ongoing.
in the case of the petitioner is still ongoing. This is a matter when? After the vacation.
Actually, interim order.
Interim order for what?
By suspension of the transfer order is
Okay, interim order to continue till the next.
deeply obliged.
I'm being animated. That would be part or what?
I forgot where I put and maybe I didn't mark it, that investigation part, the judgment. That's the problem with us now who write. We don't use the iPad too much. So slightly slow in finding the judgment. Yeah, I remember it was my judgment. I authored it. The division bench. Division bench as to when what do you mean by investigation? Investigation? Ah. I think last year before. I don't know.
Division
No,
bench.
not 24, 23 months. DB matter, criminal. It was investigation. What do you mean by the word investigation? Where is it? Where does it end? That's why I was looking for it. It's not there.
Item each, I'm unable to get a review order, madam. Your suspension order. Madam, I fix it after the immediately after vacation.
There is no review, that means.
Because
no point.
In fact, Arbeli told that
there was a review. Madam, immediately after vacation.
The copy.
Huh?
I have not been served the copy. Suspension was on 2023.
Probably you have not. This is under section 6. Your POXO case is under section 6.
8.
8.
Yes, Lord, 6.
8. Aggravated, penetrative, sexual assault.
As per allegation, there was a physical touching. There was no physical. As per allegation.
Physical touch is enough.
Yes, that will come under the section. Perhaps classified under section.
3C read with 5M. If it's a girl or a boy below 12 years, then it'll come under section 5M. Section 3 talks about, defines penetrative sexual assault. Okay, then section 5 talks about aggravated penetrative sexual assault. If it involves certain category of persons, wherein children below 12 years comes under, are to be punished under section 6. Huh?
Criminal case first. This first.
Correct. Well, I cannot look into, I'm not into that. Though I don't like it, I'll have to do it. You have got no review, that means you're not producing what to do.
That is why I'm praying for.
Okay, one last chance for this. One last chance.
Because
Okay.
I've been told verbally, madam.
Okay.
That is why I'm.
One last chance. We'll give one last chance.
Immediately after vacation, madam, nothing will do, madam.
If review order is passed, he can get it within 5 minutes. Sir. He can.
Are you scared that he'll manufacture it? He won't.
Immediately on the reopening, madam.
If it is a review order is passed, he will get it. The morning your lordship has asked to offering instruction as to whether that a.
Oh yes, acha,
Yes.
that's why I told you after. Yes. I give you time.
Yes, madam.
Then
Almost 2 years.
heinous crime also. You see,
I'm not saying that because there it was a big planning, but if it was a pre-plan and to out the petitioner by the staff of the school establishment.
no.
That's why.
I can understand when the two groups of villagers are fighting over land and all. Then they give all kinds of allegations against us. But not for office jobs.
That's why in the morning of the Ms. Peter has a producer instructor saying that it very report was invited. And they were directed.
That is again also they've told you verbally.
No. That was placed morning must be. And they were directed.
And instruction was clear, madam.
This issue was taken to re-inquire.
Serial number 6, madam.
Has any charge sheet been filed?
Charge, yes, that is under trial. The criminal case is under trial.
And how many witnesses are there? What is the stage of the trial?
But I have the informed lordship evidence.
How many witnesses?
I have no instruction. I have been told that they are not informant side is not appearing before that. That's why the matter.
The problem is you all are being informed verbally.
Instructions of my client that they are not appearing but comparting with the court. That's why matter is today. The trial.
One last topic. Mr. N.J. Katane, is given one last chance to obtain the written instructions.
And the order is
and the deliberation and the copy of the deliberation and decision made by the authority with regard to any review they might have conducted for extending the suspension of the bill. I don't think you have that. Leave the matter on.
Oblet.
Plus we hear the petitioner was appointed under the provision.
Just a minute. Yes, what is this case basically?
Hello, already,
Huh?
after that, after your lordship order, my lord, I have approached the authority.
Which order?
The lordship order, lordship will find at page. Lordship will find page 19 and the operative portion
19 of
19 of my misstatement.
yes. So what was the order?
Order is that, my lord, by this order, lordship is to stay the cancellation order, issue order, passed by the reported authority. Thereafter, my lord, I have approached the authority, submitted this order, and the consequential outcome of this stay order, that, my lord, petitioner should be ought to have been allowed to continue in her service as per the appointment letter dated 22/1/2025. But till that, as a abandoned portion. This petition has been filed by the petitioner 12 of the for a direction to the respondent to allow her the petitioner to continue her service. That's what I.
Yes.
First, I'll take it.
What is that?
Already is there. There has been a case. The.
Okay, right. Heard, Mr. E. Barwala come for the petition. Who submits that? In view of the stay of the impugned order dated 10/2/2025.
16.
Huh?
16 to 10 to 10. 16 to 10. This is I have annex matter.
Okay, 16/2/2025. The petitioners engagement as guest lecturer
Assistant professor.
as an assistant professor under regulation 3F of the APSC regulation 1954. In terms of the letter dated
22 January. Appointment notification 22.
in terms of the letter dated 22/1/25.
Yes.
Should be allowed to be continued. Mr. S. Das, the council for the
We pay for all the.
higher education. What?
Yes, sir. Higher education.
Higher education.
And we are paying for all the.
Appearing for all the respondents. Is granted 2 weeks time to obtain instruction as to why the petitioner has not been reinstated in terms of the earlier order dated under regulation here. This is the matter on when.
The term of the appointment is going to be in. So this is only for 4 months matter. And the.
This is the matter 23rd. 23rd.
My lord, matter pertains to releasing pension or finalization of pension of the petitioner. On last action, this honorable court directed counsels of the department to obtain instruction, my lord. What has happened, my lord? The petitioner has retired in the year 2021.
The B theory is missing. Huh? Who do we call? No, if they're not there, what to do?
My lord, the difficulty is that the petitioner is single parent mother, my lord. And since 2021, lordship, the department has been intimating the thing that they have sent the proposal from IS to the pension, and it has been.
Have you approached this court earlier?
Lordship, this is the contempt proceeding, lordship. In the read court, lordship, direction to the department to finalize everything within a period of 6 months. But it's almost about 1 year, my lord. What that's it? At least if petitioner pension, they could have released then also from EU to be there. Otherwise, petitioner is suffering from financial hardship, my lord. He is having old aged parent and 1 16-year-old boy.
Right. Mister?
Karim, my lord.
appears for the petition who submits that in terms of the order dated 1/5/24, passed in WPC 2275 of 2020.
Page number 19 would be the relevant, my lord. Page 19.
Right. This court had directed the respondent authority not to proceed with the deduction of any excess payment made to the petition unless a proper inquiry was made which showed that the excess payment had been occasioned due to the fault of the writ petition. This court also held that unless it was found that the excess payment had been made on the fault of the part of the writ petitioner, no step should be taken to deduct the excess amount or adjust the same from the pension payable to the petitioner. The petitioner's grievance in this case, in this contempt petition, is that the order dated 1/5/24 passed in WPC 2275/2020 has not been complied. Next step. This case has been listed four times earlier and right order dated 21/8/25. This court had directed the counsel for the respondent number 1 to bring the letter sent by the concerned inspector of school, Hailakandi, to the Directorate of Pension, showing that the proposal for payment of pension along with all required documents had been furnished by him to the Directorate of Pension. Next slide. No, continue. However, no one appears on behalf of the respondent. Respondent. By considering the fact that the respondents have not been represented, despite the court directing the counsel for the response to obtain proper instruction. This court will review that the inspector of schools, Hailakandi, should appear virtually before this on 25,
Can it come 29?
29, 4/2025 to explain as to why the proposal for payment of pension along with all the required documents have not been furnished by him to the Directorate of Pension. A copy of this order be furnished to Mr. B. Diori, Learned Counsel for the respondent number 2. Who is the paper? 3? No one appears. No.
3 and 1, both are from Education Department. Earlier direction was given to SMC 60.
No, no, SFG is only for one. Say one and two, one and to enable them to forward the same to the inspector of food. Alaka. Apply. Virtually at 10:30. Yes.